these types of pictures under 403. I believe none of these photographs.
His neck. I did print those photos as opposed to putting them on a USB because I intend to only show them to the jury and not put them on the overhead.
Judge, two responses to that. One is they don't need 9 photographs, and none of those photographs have anything to do with what the state is saying. Like those photographs don't dispute anything regarding the difficulty of getting DNA off the neck. Second, BSO got DNA off the neck, and it came back to 2 separate people, Mr. Onfroy and Ms. Sanchez, his girlfriend. So I don't know how, there's been any insinuation of difficulty getting DNA off the neck. The BSO swabbed for DNA from the neck. We obviously we presented a very complete picture of the forensics that were done by the crime scene detective. We didn't argue that anything regarding difficulty of getting DNA off the neck or anything like that. We simply mentioned all of the swabs that had been done by Detective Williams, and that certainly doesn't open the door to these inflammatory pictures.
Judge, if I might, on behalf of Mr. Newsom, the only thing I talked about was the necklace. I didn't mention anything about the body.
Understood. Anything further? Mr. Kia, you wish to be heard?
Judge, I have an objection regarding, she showed me, on this particular issue?
Yes,
I
on this issue.
Okay, so I join him in the objection.
The objection will be overruled. The state has a burden of proof here. They have a legitimate reason that they've indicated to the court for seeking to admit and publishing these photographs. The court has viewed them. They are not unduly gruesome, and none of them appear to be duplicating each other. They're all of different angles, and so your motion's noted, preserved, and overruled.
Yes, Judge.
Judge, I spoke with the state.
I had previously moved to exclude gloves that the crime scene detective found in a Cadillac outside of what has been identified as Mr. Boatwright's home. We moved to exclude them on the same grounds that we moved to exclude firearms that had nothing to do with the case, ammunition that had nothing to do with the case. The pre-trial, the court overruled that objection on the grounds that showing items that can be used in robberies is certainly relevant and permissible. The testimony by Leonard Kerr, the eyewitness to the crime, was that the suspects were not wearing gloves. He was very specific about that because he could see the race of the suspects because they were not wearing gloves. And so any inclusion of gloves in the state's case at this point is irrelevant and is more prejudicial than probative for the same reasons that showing guns that aren't involved and showing other things that aren't involved in the crime are.
Join, Your Honor.
Your Honor, as to Mr. Kerr's testimony, it's my understanding from what I recall, and I don't obviously have a transcript in front of me, is that he said he wasn't sure. He recalls, and he was pointing to the wrists that he saw, which you could see wrists even with gloves on. So because his testimony was not sure as to what he saw, whether there were gloves or not, I would argue that Mr. Kimmock's argument doesn't really take here because, again, the testimony wasn't clear as to whether or not there was, in fact, gloves on. The video itself is in evidence, and you cannot tell whether there are gloves on or not. Additionally, we don't know if they used the gloves to load the guns. That would explain the absence of DNA. So we would ask that the gloves stay in. We've only included the 2 photos.
My team is reminding me that Mr. Allen also testified that gloves were not used. I thought Leonard Kerr's testimony was very clear that the suspects were not wearing gloves, and at this point we think it's more prejudicial.
And the gloves were where?
In the white Cadillac found when we executed the search warrant for Mr. Boatwright's residence and vehicle. Oh yes, Your Honor, they were found with the mask in the backpack in the car. Both masks.
All right, over objection, I am going to allow the gloves that were found, whether or not they were actually deployed at the time. It may show preparation for the robbery, and given that they were found with the masks, I'm okay with it. Over objection.
Yes, Judge. Judge, I conferred with the state during the execution of the search warrant. Police found prescription medications for Mr. Boatwright for mental health. The state has agreed they're not going to ask any questions and instructed Detective Walcott not to bring that up. I'm putting that on the record because we certainly object to any such testimony.
And that objection would be sustained. So,
We agree.
And you agree to it,
Yes.
so
Yes.
we're all good. All right, anything else?
Judge, I saw the state showed me some pictures of Mr. Allen's residence. The issue that I have with some of the pictures, they have no evidentiary value. They just show that he lives in poverty. There's some pictures of the orange slides, which are already obviously of evidentiary value, but the other ones, they're really, I don't understand what the evidentiary value is. It just shows that he lived in poverty, and I think it's unduly prejudicial.
I think you mean Mr. Williams' house, not
Sorry,
Allen's.
Mr. Williams, sorry.
Okay, so the reason for the photos, Your Honor, there was a lot of photos taken, not many were included, to show that police actually did their job, that they executed a search warrant. I picked one photo from each angle, not even all angles of the house, just to show an overview of what the house looked like, so the jurors have a full picture of what they're looking at as to where the slides were found and where other things were found in the home. And it's not overly prejudicial due to the fact that I've only chosen a couple out of the tons that were taken at that point. There's over, I think, 300 or something.
Similarly, that objection will be overruled for a couple of things. First of all, they depict what went on the scene as it was when they went in there. You might have preferred a body cam. It sounds like that, but these stills were taken. I think it shows the work. Additionally, as to your last comment, really, one man's poverty is another man's castle. So who am I to say, what depicts someone living in poverty? I'm, something short of, living underneath a tin Quonset hut covering with no sides and the dirt floor. I'd agree that's poverty. Anything else beyond that, we all have different ideas. So.
Okay.
Two other things, Judge. One is I have two witnesses today with a lot of evidence, so I know we have a first witness who's quick. In between the two witnesses with a lot of evidence, I would just ask for a 5-minute comfort break to then just set up the evidence for the second witness, or the third witness, I should say.
The first one's quick.
But then I'm not saying for the first big witness, but then the second big witness.
Between the two.
Yes.
Between number 2 and 3?
Yes,
Oh,
please.
for sure.
And if I may have 2 minutes, we just got one more thing that was getting fixed on a USB of some videos that I had let them know was coming. It'll take 2 seconds to show them.
And Judge,
It's queued up.
I have some additional objections as to some of the evidence that will come in through Detective Foster. The state showed us some still photographs from the Driftwood video, which they plan to introduce through Detective Foster. I believe the reason they're trying to introduce them is because a civilian witness, Kanoya Sewell, identifies Michael Boatwright on that photograph. At this point, I believe that photograph is hearsay and it goes against the confrontation clause. I don't know if the state anticipates calling Ms. Sewell, but at this point, we would be objecting to that identification.
Your Honor.
I would join in that. Mr. Newsom is also depicted in those particular photos the jury has seen the driftwood video, but to specifically then pick out little sections of it to put into photographic form to highlight whatever they intend to argue with it, I would argue is not a fair representation of the evidence. The evidence is what the jury has received, the full video, and any comment the state needs to make can be made from that video.
You're proposing to introduce these into evidence, correct?
I am, Your Honor, and I would argue that they are an exception to hearsay. It's literally a listed exception as to identification, so that is why we intend to do.
Well, on the hearsay portion, yes, and as far as the, whether it's best evidence or what have you, putting in a still shot from a video is common, and it helps to focus in on a particular thing, since even, I mean, the case law even suggests that doing that without putting in the full video is not necessarily a completeness thing, because it's not a statement, but along the same lines, because the entire video is in, I don't see any prejudice in any of the parties taking a still from that's focused in to direct the jury's attention. So those are noted, preserved, overruled.
And Judge, as to the confrontation clause, as to Ms. Sewell?
It's an exception to hearsay, Your Honor. It's permissible under the case law and the statute.
So overruled.
Judge, the second objection is to the, I believe it's a printed out email that has pictures of the license plate that was used on the Dodge Journey. At this point, we would be objecting to hearsay. I don't believe Detective Foster is the one that did the license plate reader. And at this point, the entire email is hearsay.
The email just has the actual photograph that's sent to any law enforcement officer when they request the LPR records.
So you're only seeking to introduce the picture and not the rest of the email?
I can show it to Your Honor. The only thing I believe that's within it is just the header of who sent it to him, and then the bottom, which is a signature line. I can wipe that out if you'd like. I have no
If
problem.
you're just looking to get a picture of the license plate in, yes. Now,
Okay.
let's just put in the license plate, because the rest is potentially hearsay. The license plate image is an image, and again, someone can say that that's a fair and accurate representation.
Okay. I will wipe that out during the switch of evidence between the two witnesses.
Very good. Anything else?
Judge, they just showed me 4 videos. I don't know exactly which ones she wants to introduce, but they're all basically my client with money, playing with money. I think there's already been testimony that my client is a tattoo artist that would make up to $1,000 a day, that it was not rare for him to have large sums of money. And I believe that the videos are prejudicial and should not be used.
Judge, one of the videos was recorded 90 minutes after the homicide. The second one was the day after. We feel that it is relevant to show that there was, in fact, money stolen. There's been testimony that's come out that he's received a large amount of money, $15,000 to be exact, in this case, after the robbery and the homicide. We feel that it is, in fact, relevant for the evidence to come in.
I'll also allow that. Oh, objections noted. Are we otherwise ready to get underway?
Okay.
Oh, sure. While he's doing that, can I see Mr. Raris and someone from the state?
I'll go. Here.
Because this doesn't involve the other
Okay.
defendants. But
No, Judge. We were just informed that Marco Rueda is the first witness. Mr. Spears cross-examining him. We didn't know about this beforehand. Mr. Spears running back to his office to get his items in order to cross-examine Mr. Rueda. If we had known beforehand, we would have had that here, but we didn't.
And I understand that, but you should always have all your materials here. How long will it take you to get here?
10 minutes to go there and back.
She said that all four, if you delete one of them, it messes up.
Yeah, she told me.
Okay, so I don't know why, but.
And they're duplicitous, I can tell.
Yeah, so-
That's fine. No problem.
While we're waiting, do you want to see the photos? You want, or not the photos, the Instagram video? It's of Mr. Padilla's client. He's seen it, but you guys were arguing about something else with the court. Do you want to see it? No, it's an Instagram video of Mr. Williams.
Who's it coming in through, walkout or?
No, the last person.
I believe it's Foster.
Awesome.
I say I believe, check with, but because she's doing it. So like, she might have taken it. It was just here, I swear. She put it back in the thing. I'm sorry. When she comes back, I'll show it to you.
All right, we'll be in recess until Mr. Spear returns.
It's on Instagram. Okay. Yes, I think you made a follow up. Can I see it? Because I was going to show it to her. Oh. I didn't touch any videos. I just know it was in her any folders. It was in there, so when I didn't see it there anymore.
Yes, you do. You have time? Yeah.
Do I have time to get more water to drink? They want warm water.
Okay, I'm stand by.
Oh, okay, I was like, where did she go?
It's good.
The other two are the same.
Okay.
Oh, yeah. I got it. Let me look at that. Do you want to take one? Have the privacy statement, and I'll just turn it. That's fine. Yes. Yes.
This your boy 10 Toes Down, the #1 podcast. Please hit the subscribe button, hit a like button, share this video, drop a comment, tell me where you from. It's taking a long time today. That is a pretty decent judge. That state's attorney, she don't be playing. She about her work. The reason why she did not offer them a plea deal, because she want them to get 50 and 60 years in prison. That's why she didn't offer them no plea deal. And it's a premeditated murder. They going to, if they get found guilty, they going to wait for a long, long time, probably for the rest of their life. But they is a threat to society. To me, they a threat to society. You hear what Big Boy said. They woke up that morning planning to go outside and rob people. How you can like plan to go outside and rob people? And what is wrong with y'all? What is wrong with these people these days? And they little young kids. But if they get found guilty, they're gonna be crying for about 30 days in that jail cell. Straight 30 days. 30 days straight. They're gonna be crying. They think it's a game now, cause why if y'all get found guilty? All that sad face is gonna come, buddy. Look at him. He like the one in the middle. He just like he been smiling the whole trial. One in the glasses. He the shooter, so he might get the more time. He might, if he get found guilty, he might get more time. But I think we just waiting on a witness to come. I don't feel sorry for him. I feel a little bit sorry for the big fat boy who wanted to testify. I feel a little bit sorry for him, but yeah, man, because they weren't really his friends in the first place. I think he was just like a follower that do with anything they tell him to do, just before he could be friends with them. And he really didn't do nothing. Like, he wasn't robbing nobody. He just sat in the car. So, but he was in the car, so he got there sometime. But he might get time served. This happened 5 years ago. He might get time served. He might get 10 years, 5 years incarceration, 5 years on probation. That might work in his favor. Yeah, man, because at the end of the day, they really, you cannot say that's them. Yes, Fat Boy, you say that was them, the ones who's robbing X. If Fat Boy do not say that was them, they really didn't got no evidence saying it was them because they had masks and all that type of stuff on. So Fat Boy was a key witness. All of them was witnesses that we seen and testified so far. All of them was great. They followed them people all the way when he was in a store buying clothes. That probably was days later. They tracked that boy. See, the way technology is these days, I'm trying to tell you, do a crime, you won't get caught on camera. Nobody say. But they look like they ready to step back in. I mean, the jewelry coming in, they about to get back started. All right, I'll be back on the back end. Hit that subscribe button. Hit that like button. Drop a comment. Guilty, not guilty. Or hung jewelry. And we're going to be back at it when we get another break. 1.
Parties may be seated. Court will come to order. The parties present, the jurors are present. Ladies and gentlemen, good afternoon. Welcome back. Happy Friday. I trust you're all able to follow the court's directions.
Yes, sir.
Very good. Thank you. State, call your next.
State calls Marco Rueda.
Raise your right hand and be sworn.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may be seated. Please state your full name, spelling your first and last name for the record.
Marco Rueda, M-A-R-C-O-R-U-E-D-A.
You may inquire.
Thank you. Good afternoon, Mr. Rueda.
Okay.
Tell us, what do you do for a living generally?
I'm a motorcycle salesman,
Okay, how long have you been in that business?
44 years.
Okay, so safe to say you were doing that in 2018.
Yes, ma'am.
Where were you selling motorcycles in June of 2018?
Riva Motorsports in Pompano Beach.
How long during that time had you worked for Riva Motorsports?
At that time, 12 years.
Total?
Yes.
Okay, and I mean, is that the total amount of time that you worked for Riva? Because I know you eventually left.
Yes, I worked there 14 years total.
Okay. Now, as part of that, obviously, you said that you were responsible for selling motorcycles. Had you ever sold any type of motorcycles or anything related to motorcycles to Jose Onfoy, who was commonly known as XXX Tentacion?
I personally did not.
Did you know who he was?
Yes, of course.
How?
Well, honestly, from him coming into the store and all the young workers telling me, oh, you know, guess who that is? I can't believe it's in the store. Everybody's so excited.
Overruled.
Okay. So when he would come in, it'd be a little bit of fanfare?
Yes.
They'd be excited to see him?
Of course.
Okay. So, and he purchased from the store before?
Yes.
So would you say he was a frequent customer?
Yeah, I mean, he was a good customer.
Okay. So on June 18th of 2018, were you working that day?
Yes, I was.
And did you see Mr. Onfoy in the store that day?
Yes, I did.
Tell us the circumstances of how you interacted with Mr. Onfoy.
Well, the salesman in front of me, Carlos, is basically the salesman that usually took care of Mr. Osprey. I sat behind him. And he came into the store that day. Carlos met him at the front door, and Carlos showed him around the showroom for some different, different bikes and different toys he was looking for.
Okay. And as from your understanding, what you were able to witness, did it appear that Mr. Onfoy was interested in purchasing motorcycles, plural?
Well, he's always looking for different motorcycles, and he actually came in looking for something automatic, like an automatic transmission type of motorcycle.
Okay.
Which at the time we didn't have any, so he didn't purchase anything.
Right. Okay. So he was looking for it, but no purchase was made because you guys didn't have that type of particular model or whatever he was looking for.
Yes.
Okay. So how long was Mr. Onfoy in the store from what you could see?
From what I remember, I don't think he was there maybe an hour.
And then, what were you doing during that hour? You were also helping your own customers?
Yes, I was in the process of selling a watercraft to a gentleman and finishing up and waiting for my watercraft to be finished and brought back from the warehouse.
So once your sale is complete of the watercraft that you were selling, does it require you to also then go outside and assist with that?
Yes, of course.
So tell us about that, because as you were going outside to assist with the watercraft, what happened as you were outside?
Well, as I was walking outside with my customer and walking to the back of the parking lot at Riva, our parking lot basically is set up where there's only one entrance in from South Dixie Highway and then one exit out. So we usually bring all the things that we're going to deliver towards the back end of the parking lot. So I was walking towards the back of the parking lot with my customer, and Mr. Osprey drove by as I was walking to the watercraft I was going to deliver.
Now, you say drove by, you're talking about the BMW i8 that the victim owned and was driving?
Yes.
And you recognized it as his car because you've seen it before?
Yes.
Okay, and then when you see Mr. Onfoy pass by you in his BMW, what happens next?
Well, basically, I kept walking towards the watercraft, and then Mr. Osprey made a turn to go out the back exit, and that's when I saw an SUV come and block him, and just where he couldn't drive out. And at that point, I saw two gentlemen jump out of the SUV.
From what side of the SUV?
They were coming out of the passenger side, front and rear door.
Okay.
Passenger side, right side.
And then what happened next?
The two gentlemen came up to the car, Mr. Osprey's car, and approached him, and everything was happening like really fast, and me and my customer were even looking at it like saying, "Whoa, what's going on?" And then we saw the passenger door open and the gentleman jump out.
The passenger door of the BMW
Of the
i8?
BMW,
Okay,
yes.
just making sure you're not talking about the suspect vehicle.
No.
Okay, so the passenger door.
The passenger door of the BMW opened up, and gentleman jumped out and kind of ran away. And then I saw the two gentlemen on the driver's side of the BMW, and they were talking and grabbing and so forth.
Now, when you say talking, we are talking in a
Right.
normal tone and what sometimes people say is an inside voice. Is that how they were talking?
Well, I mean, I was maybe 50, 60 feet away from them. So, I mean, I heard voices, but I couldn't make out what they were saying.
Understood. Were you able to discern if the voices were shouting?
I mean, I would imagine, yes, they were shouting because there was a lot of like struggling going on.
Okay, and who did you see the struggling going on between?
Well, it started, both gentlemen were kind of struggling by the driver's door, but then one gentleman comes around the back of the BMW with hands. The door was open, it's a door, so it was open, and that gentleman's trying to reach in and grab it.
Okay, were you able to see what the second person was grabbing at?
No.
Okay.
No.
And then while the second person ran around to the passenger side of the victim's vehicle and is grabbing, what is the first person doing?
Well, the first person's standing over the door, and he had a gun. It looked like a rifle because it didn't look like a handgun.
You've seen rifles before?
Yes, ma'am.
Okay, and when I know the monitor is a little bit covering, but each time you're referring to it, you're holding both your hands together. Can you just stand up where you are and show us how the first person was holding the rifle?
Well, I saw the person over Mr. Osprey holding the rifle gun, whatever it was. It was a short handgun. It wasn't like a long rifle.
Okay, so possibly a short barrel rifle that you could see.
And I saw him, struggling, reaching into the car. The other gentleman also reaching, and then I heard the gunshots.
Okay, thank you. How many gunshots did you hear?
I think I heard 3.
And which side of the vehicle were the gunshots coming from?
It was on the left side, the driver's side.
The driver's side. Now, what were the physical descriptions of the two gentlemen, starting with the one that was holding what you described as a rifle?
I saw one gentleman was definitely a larger frame than the other gentleman that ran around the passenger side of the car.
Now, when you say larger frame, because I know in people's everyday vernacular, large could mean a variety of things. Do you mean large by weight or large by height, or what do you mean?
In stature, he wasn't a 300-400 pound man, no way.
Okay.
But just bigger in stature, the way he was standing, compared to the other gentleman who looked a little thinner, more lean.
Who was taller out of the two?
From what I saw, the gentleman with the rifle.
The one that shot the victim?
Yes.
Okay. And were you able to tell from your vantage point what the race was of the shooter?
No.
Did you see a firearm in the other suspect's hand, the one that was around on the passenger side?
I did not notice another handgun or rifle.
Okay. When you say you didn't notice, you just couldn't see from your vantage point? Is it possible he had one, you just don't know?
I don't know.
Okay, that's fair. Were you able to see what race the second person was that was on the other side of the BMW, the passenger side?
No, I could not tell because they were wearing masks.
That's what I was going to ask you. What, if anything, was on their face or their head that obstructed your view?
I really couldn't see. They were wearing full clothes, like they were wearing masks. I couldn't tell what nationality they were.
Okay, that's fine. Were you able to discern what clothing? Were you able to see that detail?
From what I remember, she was dark clothes.
Okay.
It wasn't anything that I remember.
And after the taller of the two suspects shot Mr. Onfoy, what happened next?
Well, from what I remember seeing, they just basically had something in their hands, okay, and they just basically ran back into the SUV, jumped in the SUV, and took off.
All right. Inside the store, I'm just going to backtrack just for a little bit. You were able to see Mr. Onfoy's demeanor. What was his demeanor inside the store?
Oh, he was such a nice young man. I mean, I never had any issues with him. He always came in super happy, saying hello to everyone. Everyone, just all the salesmen always make sure he says hello, and that's the way he seemed that day.
Okay, so it was very pleasant as far as you recall right before he was killed.
Yes.
No further questions.
Who's doing that first cross?
No cross on behalf of Mr. Bishop.
All right, on behalf of Mr. Boatright?
Come on. Briefly, Judge.
Good afternoon, sir. Good afternoon. You testified in direct examination that both gentlemen were inside the car?
No, sir. One was reaching into the car on the driver's side.
Right. So the person on the driver's side was actually reaching through the window inside the car?
Yes.
Correct? And you testified that the other person went around to the passenger side of the car?
Yes.
And they were fully inside the car at one point, correct?
I mean, half the body, they were reaching in.
So half their body was inside the car?
Yes.
The waist up was inside the car?
Yeah.
Right? So their hands would be inside the car?
Yes.
And both seem to be struggling for something inside the car, correct?
From what I saw, yes, sir.
A moment. Nothing further. Thanks.
No questions, Judge.
George, you said no questions.
No questions, thank you, Judge.
No redirect, Your Honor.
Thank you. You're excused. Please do not discuss your testimony with any other witness. State call your next.
State calls Detective Marshall Wolcott.
Raise your right hand and be sworn.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may be seated. Please state your full name and spell your last name for the record and your first name.
It's Detective Marshall Wolcott. My last name is spelled W-O-L-C-O-T-T.
So your first name, please?
It's M-A-R-S-H-A-L-L.
You may inquire.
Thank you, Your Honor. Good afternoon, Detective.
Hello.
How are you doing?
Good.
Can you tell the ladies and gentlemen of the jury who you work for?
I work for the Broward County Sheriff's Office. I am a crime scene unit detective.
And how long have you worked for the Broward Sheriff's Office?
Since 2006.
And when you first started working for the Broward Sheriff's Office, did you immediately go into crime scene?
No. I first worked road patrol for 8 years. Then I was a criminal investigations detective for a year. And then I've been in crime scene now since 2016.
All right, so road patrol. Walk the jury a little bit through what types of things you do as a road patrol deputy.
A road patrol deputy is like a standard police officer that goes to calls and responds to incidents of domestic violence, things of that nature, any and all calls.
And then you said you were a detective in the, I think you said the criminal investigations department, correct?
Correct. Yeah, I did property crimes in the city of Pompano Beach.
And that would include things like robberies?
That would include things like burglaries, fraud investigations, things of that nature.
All right. And then what year did you go into the crime scene unit?
2016, March of 2016.
And did you immediately go into the crime scene unit as a detective?
Yes.
All right. So tell us a little bit about the training that you've received in order to be a crime scene detective.
So we have an extensive training program where we do a year-long field training program where we go over photography and collection of DNA and collection of fingerprints and things of that nature. We also do a lot of outside agency training like blood spatter, reconstruction, things of that nature.
Do you keep up on the training?
Yes.
Do you keep up on how, I guess, evidence collection is evolving with, as time goes on?
Yes.
All right. Besides on-the-job training, can you tell us a little bit about some of the actual trainings you've taken for evidence collection?
I've taken blood spatter, about 120 hours worth of blood spatter courses. A bunch of other trainings and very specific things like fiber collection, other things of that nature.
How about photography?
Yes.
Okay, so tell us a little bit about what you learned and how to document a scene through photography.
When documenting the scene, you want to take pictures of the entirety of the scene, so overalls, intermediates, and close-ups. Usually we'll sweep from one side of the room to the other and try to get as many angles of the room as possible to get full coverage and documentation.
All right. How about DNA, or the collection of DNA, I should say, and swabbing items of evidence? What kinds of training have you taken on that?
The standard trainings that go through BSO through the crime scene unit.
All right, and do you keep up with any of the DNA trainings that are provided to you and to your unit?
Yes.
All right.
I'm also one of the field trainers that trains the new incoming detectives as well.
Okay. And what about dealing with homicide victims and documenting homicide victims? Have you been trained in how to photograph them as well?
Yes.
Now, were you working as a crime scene detective on June 18th of 2018?
Yes.
Do you recall being dispatched to a scene involving the murder of Jose Onfroy on that day?
Yes.
Where were you first dispatched to?
I was first dispatched to the hospital, which is North Broward Hospital.
And where was that hospital located?
It's in the city of Deerfield Beach. It's 201 East Sample Road.
Okay. So how does someone in your unit get called out? How does that work?
My sergeant called me and said that I would be responding.
Overruled.
You can answer.
My sergeant called me and requested I respond to the hospital first to document the victim in the case.
Now, when you go to any scene, are you made aware of at least general facts of what you're responding to so you know what you need to do when you get there?
Yes.
Okay, so certain facts are told to you on the phone by your sergeant or when you get to the hospital?
Both. So certain facts are told initially, usually just the basics, but then most of it's gotten when I meet with the deputy that was standing by at the hospital or the detective that's there.
All right. So do you recall what time you responded to the hospital?
Yeah, I have it in my notes.
If you need to refresh your recollection with your report, please do so to yourself and look up when you're done.
I arrived at approximately 1700 hours at the hospital.
So I'm really bad with military time.
It's 5 o'clock in the afternoon.
5 o'clock in the afternoon, all right, thank you. So 5 o'clock, do you recall when you got there, was there multiple deputies on scene, just one? What did you see when you first got there?
I spoke with Detective Curtis. He's a homicide detective.
All right, and
I got all the preliminary information from him.
what is the purpose of having law enforcement present when a homicide victim is initially brought into the hospital?
It's for security and making sure that people aren't going in and out of the, in this case, the trauma bay, where he was being treated for his injuries.
All right, so tell us generally what you were informed of so that you knew what to do when you got there.
I was...
Effect on the listener, Your Honor.
Overruled.
You may answer.
I was informed that the victim had been shot and that I would be documenting his injuries and collecting his clothing and any DNA from his person, like his fingernails, his neck, etc.
All right. When you get to the hospital, are you led into a room? Is the victim located in a particular room? Is there security there?
Yes, he was in a trauma bay number 40, as I recall. It's one of the first trauma bays when you go to the hospital in the emergency room.
And can you describe to us, to the ladies and gentlemen of the jury, what you observed when you first entered that trauma bay?
I first observed the victim lying on the hospital gurney.
Was he clothed?
No.
Was there a white sheet over him?
Yes.
And did you begin to start documenting him as is?
Correct.
Do you clean him up in any way while you're documenting him at the hospital?
No.
Joint Defense Counsel, which been previously marked as number? I. As states I for identification. Again, it's a composite of 9 photos. May I approach the witness, Your Honor?
May.
Detective, I'm now showing you what's been previously marked as state's composite II for identification. Can you take a look at those for me? Do you recognize those?
Yes, I took those photos.
And what are they?
They are photos of the victim
When?
from the hospital.
Okay, and do they fairly and accurately depict the way that the victim looked when you began to document him on June 18th of 2018?
Yes.
Your Honor, at this time, the state would enter into evidence that's been previously marked as State's Exhibit II as State 34.
Any additional objections?
35.
Reviewing previous objections, sir.
Nothing additional.
Oh, 35, I'm sorry.
No additional.
All right, over objection, what was previously marked states II for identification shall be received in evidence as states 35, a composite of 9. You may publish to the jury.
Yes, Your Honor. I was going to ask if I may just publish it to the jury themselves, and I will hand them to the jury so that they can look at it.
All right. Since there are 9 photos, folks, she's going to hand you the packet and perhaps look at them one at a time and start sending them down the line that way.
All right, Detective, let's talk about these photos, and I will show them to you and then point them to the jury as we kind of talk about them. But you specifically documented his neck, correct?
Correct.
Was there a reason for that?
He had injuries on his neck.
Okay. And can you describe to this photo, what we're looking at here.
It's the back of his left shoulder. He had a gunshot wound to the neck and shoulder area here.
And the tubes that we're seeing, what is that from?
Those are placed there by medical staff during life-saving procedures.
So you truly document the victim as he is after his time of death, correct?
Correct. That's more on the other side of the neck.
And again, this comes back to your photography training where you need to get all angles of a scene or a victim's body or any piece of evidence?
Correct.
Is it safe to say that there was blood all over the victim's neck?
Yes. That's more pictures of the side of the neck as well.
And is that more medical life-saving measures that we see on him?
Correct.
So when you get there, this is after, is this after hospital staff, nurses, and doctors are trying to save his life?
Yes, it's after he's already been pronounced deceased.
Do you know how many people, in fact, touched his body in trying to save his life?
I'm sure there was multiple doctors that were working during that time.
And what are we looking at in this photo?
That's on more the front of the neck.
Again, are we seeing blood?
Yes, there's a lot of blood on the victim's neck.
Now, when a victim who's been shot gets to the hospital, do they remove all items of clothing and jewelry that they are wearing?
Typically, yes, they remove everything and they place it on the side.
And was that done in this case?
Yes.
And what are we looking at here?
We're looking at the front of the victim.
Okay. And again, do we see apparatuses and blood all over the front of his neck?
Yes, he's connected to multiple medical implements and he has a blood on the front, sides, neck, chest area.
So talking about the clothing and any items that were found on his body when he's brought into the hospital, did you say that they were there with him?
Yeah, they were taken off by hospital staff and then kind of placed on the side. That's usually what they do for us. Understanding that we're going to be collecting them as evidence, so they place them on the side, sometimes in paper bags, sometimes just placed on the side.
And did you in fact photograph those items at the hospital as well?
Yes.
Was there any other items besides clothing that was found on the victim's body?
Yes, he also had jewelry.
Jewelry. And besides jewelry, was there any foreign objects removed from his body that were also collected?
Yes, they removed a projectile.
Showing defense counsel has been previously marked as states JJ for identification, a composite of 6 photos. May I approach the witness, Your Honor?
You may.
All right, detective. Now showing you what's been previously marked as state's composite JJ, a composite of 6 photos. Can you take a look at those? Do you recognize these?
Yes,
How do you recognize them?
they were the photographs I took that day.
And do they fairly and accurately represent the clothing and jewelry and projectile that you just discussed?
Yes.
Your Honor, at this time, the state would enter into evidence which we previously marked as state's JJ for identification, a composite of 6 photos.
No objection.
No objection.
Without objection, what was previously marked states double J for identification shall be received in evidence as states 36, you may publish.
Thank you, Your Honor. Would you like me to do it the same way as I did, or can I use the overhead this time? There's,
I haven't looked at them. Are they graphic?
no.
Then you may use the overhead.
All right, detective. Let's go through the clothing that you collected first. What are we looking at here?
Those are the victim's red shorts.
And I see that there's some cuts to the clothing. Is that standard after a victim is shot is brought to the hospital to receive life-saving measures?
Yes.
Okay. And what are we looking at here?
Those are the victim's white socks.
And here?
Those are the victim's gray underwear.
And here?
Those are the victim's white sneakers.
And then here?
This is the projectile that was collected by medical staff.
And do they place that in that blue cup that we're seeing?
Correct.
And is that just a close-up of it?
That's a close-up of the projectile.
Showing defense counsel what's been marked as MM and LL for identification. May I approach the witness, Your Honor?
You may.
All right, detective. Showing you now what's been previously marked as states MM and states LL for identification. Can you take a look at these?
So this is the victim's gold chain.
And is it in the same or substantially same condition as it was when you photographed it and collected it that day at the hospital?
Yes.
Okay. And how about here? What are we looking at? MM.
This is the cup with the projectile inside of it that was collected at the hospital.
Okay, now when you collect these, are they in the plastic like we see here today?
No.
Okay, so how did you package them?
We packaged them inside of these brown paper bags, and then they get sent to evidence control from there.
All right, and is the clear plastic for courtroom presentation only?
Correct.
Your Honor, at this time, the state would enter into evidence what's been previously marked as states LL for identification and states MM for identification.
No objection.
No objection. No objection.
Without objection, what was previously marked states LL and MM for identification shall be received into evidence as states 37 and 38 respectively. You may publish.
Thank you, Your Honor. Your Honor, may I hand these to the jurors?
You may.
Hey, this your boy 10 Toes Down, the #1 podcast. Please hit the subscribe button, hit a like button, share this video, drop a comment, tell me where you're from. Hey, this your boy 10 Toes Down, the #1 podcast. Please hit the subscribe button, hit a like button, share this video, drop a comment, tell me where you're from. Hey, this your boy 10 Toes Down, the #1 podcast. Please hit the subscribe button, hit a like button, share this video, drop a comment, tell me where you're from.
All right, Detective Volcott, let's talk about this chain a little bit. When you collected it, did you notice anything about it with regards to any fluids on it?
I noticed that the victim's blood was on parts of it. I noticed that there wasn't blood on other parts.
Okay. And are those red stains that we're seeing on the chain what you're talking about?
Yes.
And there as well on the lock itself?
Yes.
Now, because you saw blood on the chain, were you told that the chain might have been important in your investigation when documenting this evidence?
Yes.
And what were you told?
I was told that.
Judge, objection to your saying what you told about the change.
Effect on the listener as to how he conducted his investigation, Your Honor.
Overruled.
You may answer.
I was told that the chain was, someone tried to remove the chain from his neck. So I swabbed the chain for possible DNA of somebody that could have possibly grabbed the chain.
You said you swabbed the chain. Did you swab anything else when you were at the hospital?
Yes.
What else did you swab?
I swabbed the victim's fingernails and I swabbed his neck as well.
Okay, and what was the purpose of that?
It's also if somebody is trying to grab, his neck or that area, that possibly they would be leaving some traces of DNA behind.
Now, when you're swabbing the victim, as we saw in those photographs of his neck, there's a lot of blood, there's a lot of medical apparatuses, so how do you work around that? Or try to, I should say.
That's just it. We try to work around it the best we can. And then obviously then we send that down to the lab for analysis where they can decipher whether it's blood, whether it's not blood, and whether there's different DNAs on the swab or not.
The jury heard a little bit about how DNA is swabbed, or how swabs are taken, but if you can just explain a little bit about your process and how you went about swabbing the victim's neck that day.
So the same way, we take 2 cotton swabs and we put sterile water on the tips of those swabs, and then we swab them together as if they were one swab. And then after we swab that certain area of the necklace or the neck and the fingernails, we place them into those boxes. They then get submitted to the lab for analysis.
Showing defense counsel with been previously marked as state exhibit KK for identification. May I approach the witness, Your Honor?
You may.
Detective, I am now showing you what's been previously marked as State's Exhibit KK for identification. Can you take a look at that?
Yes, this is my bag.
You recognize it?
Yes.
How do you recognize it?
This is my handwriting, and these are the item numbers of what's inside of the bag.
All right. And have you checked on it, looked in it, and noticed that it's all the same as it was when you first swabbed the victim that day and then packaged it?
Yes.
Okay. And nothing's been damaged or changed with any of it, correct?
No.
Okay. Your Honor, at this time, the state would enter into evidence what's been previously marked as State's Exhibit KK as
39.
39? 39.
No objection. No objection. No objection.
Without objection, was previously marked states double K for identification shall be received in evidence as states 39.
And Your Honor, as it's biohazard, I'm not going to open the bag.
Understood.
Detective, let's just talk a little bit about what's in this packaging. We see some writing all over it, right?
Correct.
Can you tell the ladies and gentlemen what all that writing means?
So the writing, the green sticker on the back is from the lab. That's the lab number that they give it to show that it went to a lab for analysis. The writing on the front is my handwriting of all of what's inside of there, of the different swabs that are inside there. And the barcoded ones, the white stickers that are on the back, those are from evidence control when they gave it barcodes so that it could be tracked properly.
And is all this writing to make sure that it's secure and kept in the proper place and we know who's touching it and when they're touching it?
Correct.
Overruled.
And the red evidence tape, are those your initials?
Yes. So we seal every bag, and anytime a bag is opened somewhere else, it's not opened in the same seal, it's opened somewhere else, and then it gets resealed and signed with whoever opened that bag otherwise.
Okay. So the first swab that's listed on here is SL1. It's a buccal swab. What is a buccal swab?
A buccal swab is an elimination swab from somebody that we're trying to either eliminate or not eliminate, but it's DNA that we know is from a known victim. So what we'll do is we'll swab the inside of a person's mouth for about 10 seconds on each side, and then that gets used as their standard. So in that case, that was Scott. He was one of the people that was first on scene, and because he may have came in contact with the victim when he first saw the incident, we made sure that we had one of his swabs for elimination.
Okay. The second swab here is swabs of a necklace. So it says swabs, so there's more than one, correct?
Right. Again, I always use 2 swabs, and those 2 swabs get swabbed together as one, and they get placed inside of the cardboard box together that way. That way, when they get analyzed, it's up to the DNA analyst to, if they just choose to use one, then there's a second one that could be tested at a later date and time if needed.
When you're swabbing this necklace, are you just touching one aspect of the necklace, or are you swabbing, continuously through the necklace to try to get as much of a DNA profile as possible?
I'm swabbing all of the areas to get as much of a DNA profile on somebody that could have potentially grabbed it.
And is that standard in the collection of DNA potentially?
Yes.
also see swabs of neck collected.
That was swabs of the side of the victim's neck.
And how did you go about actually swabbing the victim's neck? Was it one continuous swab like you just discussed?
It's a continuous swab, and again, I'm trying to stay away from the victim's blood because that's a lot more DNA that is of his. We're trying to get foreign DNA. That's not the blood, but it is a swab of the victim's neck in that area.
Was that easy for you to do, detective? With what the
No,
victim
in
looked
this
like?
situation, there was a lot of blood on his neck.
Now I also see swabs of right fingernail and swabs of left fingernail. Do you do the two swabs that you just described for all 5 fingernails as one?
Yes,
And then the right hand, the same thing?
correct.
Alright, so after you're done documenting the victim, his items that he was wearing, any projectiles that were found in his body, what's next in your investigation for this case?
So once I was done at the hospital and finished collecting all of those evidence items, I then responded to the scene to assist Detective Williams on the scene.
When you say scene, which scene are you talking about?
The actual shooting scene with the BMW.
When you get to the scene, describe to us what you see.
So I saw the victim's BMW. It was parked just outside of the entrance of Riva Motorsports.
Was there a crime scene tape up, deputies there, detectives there?
Yes, all of the above.
Did you see civilians, bystanders looking on to see what was going on?
Correct.
And when you get there, are you asked to, I guess, collect any evidence from any potential witnesses that were there?
Yes, I was requested to assist with processing the vehicle for fingerprints using black powder. And then after we were done with that aspect, I met with the witness, Scott, and I documented photographically what he was wearing, and I collected the vehicle swab or the elimination standard from him.
Did you also fingerprint him at some point as well?
I believe at some point.
Showing defense counsel looks to mark the state's NN for identification. Mr. Diaz, is it?
Yes.
Commissioner approach.
Ma'am.
Detective, showing you what's been previously marked as state's NN for identification. Can you take a look at that?
Yes.
Do you recognize it?
Yes.
And how do you recognize it?
Those are a set of standard 10 prints, which is that smaller card, and then it's a set of what we call major case prints, which is his palm and the rest of the sides of his hands and his fingertips of each hand on each side. So it's a set of elimination standards, again, from the witness who was on scene and may have made contact with the car, things of that nature.
Your Honor, at this time, the state, well, let me ask you, are these in the same or substantially same condition as they were when you first fingerprinted him?
Yes.
At this time, Your Honor, the state would enter into evidence that's been previously marked as states NN for identification as states 40, I believe.
No objection.
No objection.
Without objection, what was previously marked states double N for identification shall be received in evidence as states 40. You may publish.
Thank you, Your Honor. Detective Wolcott, were you trained in taking fingerprints, rolling fingerprints, I should say, off of individuals?
Yes. I've been trained in it multiple times, as well as I now also teach how to roll fingerprints as well.
How long have you been teaching how to roll fingerprints?
Objection bolstering.
Overruled.
You may answer.
Since I became an FTO, probably about 2 to 3 years ago.
Can you explain the process of rolling someone's fingerprints?
So you will cover all of the rich detail with a black ink, and then you're just going to roll them onto the paper, each one, making sure that you're able to see all of the friction-rich detail.
And when you say ridge detail, are those little lines that we see on all of those black markings?
Correct. And again, this gives a set of standard prints that they know came from this witness.
All right. And you also said you got a set of major case prints from Scott as well, correct?
Correct.
Is that what we're looking at here?
Yes.
Is it somewhat like a palm print as well?
Correct. So it's his palm, it's the blade, or what they call the writer's palm of his hand, and then it's also the fingertips that you see on top of it. So things that the normal standard 10 print card don't get, we also try to make sure that just in case, again, if he had touched the side of the car, and it was somewhat of the palm, that we have a set of standards of the palm as well.
Were you made aware of why you were being asked to fingerprint Scott on that day?
Yes.
What was that reason?
Because he apparently came up to the car to check on the victim and may have came in contact with the car.
Okay. You said you were assisting crime scene lead investigator Clint Williams, correct?
Yes.
What else did you do on scene to assist?
That, like I said, I processed the vehicle with black powder prints and documented that witness.
Did you have any other involvement in collecting any evidence at the scene of the shooting and the homicide?
No.
At some point, are you involved again in this investigation?
Yes.
What's the next date that you are now involved in the investigation here?
The next date would be July 5th.
And what happened on July 5th?
On July 5th, I made contact with Michael Boatwright to document him and collect his buccal standard, or his DNA standard.
Okay, and where did you make contact with Michael Boatwright?
That would be at the public safety building, so our main office.
Right, and why were you asked to go to the public safety building to meet with Michael Boatwright?
Because that's where he was in custody and that's where he was being interviewed.
So he had been arrested at that point, correct?
Yes.
Okay. And you said you took vehicle swabs?
May I?
right? Prior to taking a standard buccal swab, it's common that you would ask them for their standard information like name, date of birth, or something like that to identify them.
Correct.
Showing defense counsel with the mark of states 00 for identification. Commissioner Brooks, Your Honor.
You may.
Detective, I'm now showing you what's been previously marked as states 00 for identification. Can you take a look at that for me?
Yes.
Do you recognize it?
Yes.
And what is it?
It is the buccal swab or the elimination standard that I got from Michael Boatwright.
Okay, and how do you know that that's the buccal swab that you took from Michael Boatwright?
Because I have all the information listed on here and I signed the bottom of it.
Okay, and is it fairly, substantially the same, that it was when you first swabbed him?
Yes.
Okay, and all the tape that we see in the writing is because of the lab when they tested it?
Correct. When the lab opens it, they put their own seal on it and sign the seals as well. And they have that writing. The green sticker, again, is the sticker that the lab puts on it to track it. And that green writing is also from the lab.
Your Honor, at this time, the state would enter into evidence what's been previously marked as State's Exhibit 00 for identification.
Sorry, objection. May I go sidebar again, please?
As State's 41.
Without further objections, what was previously marked states 00 for identification shall be received in evidence as states 41.
All right, Detective. So again, this is biohazard, so we're not going to open it, but same swab process that you talked about before?
Correct.
Okay, and the writing, the green is the lab, and you label it, do you label it with the defendant's name?
Yes.
And you label it the date that you swabbed him?
Yes.
And all this evidence tape is signed, dated, and I see your initials, correct?
Yes.
Okay, and that's for each time that it's opened, you then have to reinitial it?
Correct. Anytime it's opened, it has to then be resealed and initialed once it's put back.
Do you have any involvement the following day regarding Michael Boatwright's residence?
Yes.
What was your involvement?
I was tasked with meeting with Detective Curcio and documenting the search warrant and collecting any evidence from the search warrant.
What was the address of the residence that you went to?
The address was 1617 Northwest 15th Street in Fort Lauderdale.
Do you recall what time you responded to that address?
At approximately 1800 hours, which is 6 o'clock in the afternoon.
You're catching on. I don't know military time. Okay, so was this pursuant to a search warrant?
Yes.
And when you get there, describe to us the scene.
It was the residence And again, I met with Detective Curcio. He gave me some information and he gave me a copy of the search warrant.
And based on that search warrant, do you then start doing your part of the investigation there?
Correct. So what I do is I'll go inside the residence. I start photo documenting, like I previously mentioned before, sweeping from left to right, making sure I take overalls, intermediates, and close-ups. Then as we continue on through the search warrant, and as we start looking for things, everything is documented and photographs are taken throughout the residence.
And within the search warrant, or I guess I should say it this way, when you first get there, do you photograph the overall outside of the home
Yes.
to document it? And then do you eventually make your way inside as well?
Yes.
Okay. Showing defense counsel what's been previously marked as state PP for identification. Permission to approach, Your Honor?
Yeah.
Detective, I'm now showing you what's been previously marked as State's Exhibit PP for identification. Can you take a look at that? And do you recognize it?
Yes.
How do you recognize it?
That was the USB drive that you showed me that had my photographs on it.
All right. And do those photographs that I showed you on this USB fairly accurately describe the photographs and depict the photographs that you took on that day?
Yes.
Your Honor, at this time, the state would enter into evidence that's been previously marked as State's PP, as State's 42.
Renewing previous judgment.
Same judge.
Same judge.
Over objection was previously marked states double P for identification shall be received in evidence as states 42. You may publish.
Thank you, Your Honor. Thank you. Okay. Showing you the first photo in this USB. Is this the outside front entrance of the home?
Yes.
Let me just get rid of this. Okay. And this is your overall documentation of the front of the home, correct?
Correct.
And is this just the address, the number of the home?
Correct.
Okay. Now we're making our way inside, correct? Is this the front door?
Yes, this is the front door.
Walk us through the photographs as we get to each one. What are we looking at here?
So this is the living area, and then like towards the left-hand side is kind of like the open kitchen area where the refrigerator and things of that nature are. That's on like that side of the wall. That's the other side of the living room.
The other side of the room, you said?
Yes, that's the other side of the living room. So like the front door would be
And is that looking at the front door?
correct. Well, that's looking at the side door.
Side door, okay.
Yeah, so more towards the kitchen area, because you can see the car in the background. That door is not the front door, that's the side door, and that's the refrigerator that you see. So that's on when you enter into the front of the residence, that's on the left side.
Okay, and that car that you just mentioned through the window that we can see, is that white car we saw in the first photograph of the overall home?
Correct, that's the white Cadillac that was parked in front of the residence.
Okay. What are we looking at here?
That is the kitchen. So there's actually two refrigerators. There's one that's on the one side of the door, and there's the one that's on the other side of the door, and that's the rest of the kitchen.
And here, is this just a close-up of the kitchen for purposes of documenting the scene?
Yes.
And again, taking more documentary photos of the scene in the kitchen and wherever you're photographing, correct?
Yes, just more documentation of the kitchen.
And what are we looking at here?
So this is the hallway that leads down to the bedrooms. So on this side of us would be the living room, and on that side would be the kitchen. That's the wall that's in the middle dividing the kitchen.
And is this you making your way into one of those bedrooms?
Correct.
And what are we looking at here?
That's inside one of the bedrooms.
And here?
Also inside the bedroom.
And here?
That's one of the bathrooms.
Is that just a close-up of the bathroom and where you're searching?
Correct.
Is this another bedroom?
Yes.
Okay, and is this another bedroom within that hallway we saw in the earlier photo?
Correct. That is the most rear bedroom over on that side of the house, on the right side of the house.
Is this that same bedroom that we were just looking at, but a different angle?
Yes. So starting from this side, that's that corner, and then, like I said, we usually sweep from this side from left to right. So that's like the left side of the room as you first walk in.
So is the purpose of doing it this way kind of to be like one of those flip book, those story books that you see every portion of the scene?
Directional leading.
System.
And what are we looking at here?
That's another photo of the same bedroom.
And again, are you moving closer and closer with each photograph? Is that what I'm seeing here?
Yeah, it's an overall, and then an intermediate, and then a close-up. That's generally how we work. We do overall, intermediates, close-ups.
And then what are we looking at here?
That's on the right side of the bedroom as you walk in.
And here?
That is a close-up of the Nike shoes from the bedroom.
And here?
That is so the last photo was an intermediate shot of it. This is a close-up of them so that you can see further detail.
And here?
That is a pair of black jeans. And that is a pair of camo shorts.
And here?
That is another pair of black jeans, because there was two. There was one that was branded Smoke Rise, and there's another one that was branded Levi.
And here?
That was some mail that was inside of the bedroom that had his name on it.
Okay. Do you also document outside the residence?
Yes.
What was the purpose of documenting outside the residence?
There were trash bins outside of the residence, as well as kind of this overhanging carport, and these two cars that were parked here.
Okay. Is this those trash bins that you just referred to?
Yes.
And do you go through trash when you're executing a search warrant?
Yes.
And what did you find?
That was the Levi brand jeans that I had mentioned earlier.
Are those same jeans?
Yes.
And what's here?
That is a Champs bag.
Is that also inside the garbage?
Yes.
And here?
That is a Champs receipt, and again, some of the other garbage outside.
And can you tell us the total?
Objection, hearsay.
I believe it says $407.
Is that just a?
Yeah, that's a close-up one. It's a little bit easier to see. It says, yeah, $407.
And actually, go this way. The date, if you could tell us as well.
objection to your study?
Oh, I see it now. Okay, it's 7/1 of 2018 at 4:21 p.m.
And is this just the back of the home?
Correct, that's the backyard of the residence.
And again, is this to just overall document the entire scene?
Right, so that you're able to see what the residence looks like for both the outside and inside.
And then you mentioned that there was a white Cadillac outside in the driveway as well.
Yes,
Is that white Cadillac?
yes,
And you document it on the scene first?
yes.
Now, what are these stickers that we're seeing here?
So the same as the evidence seals that we put on paper bags, we put them on vehicles too, to show that they haven't been opened or tampered with when they're being towed. So the initial general documentation of the vehicle was done outside, but that was just the exterior, just the preliminary. And then once we realized that there was evidence inside of the trunk, we photographed it, closed everything, sealed it, and then sent it to my unit garage to be documented on a different, separate search warrant at a later date. Because we were doing the documentation for the search warrant of the house, so a new search warrant needed to be given for the vehicle.
So do you seal all aspects of that vehicle before it gets towed?
Yes,
And are we seeing your initials and CCN number?
yes, those are my initials and my CCN, also
And-
my badge number. Same.
I was going to ask, is the CCN a badge number?
Yes,
Okay. Again, is just more documentation of the seals?
yes, all of the seals were photographed and documented.
Now, where is this photograph taken?
This is inside my garage.
And is this part of the Broward Sheriff's crime scene unit office?
Correct, yeah, it's attached to my crime scene unit office.
And is this where you executed a search warrant on the vehicle?
Yes,
And do you again document each side of the vehicle where the seals are to show that they're not broken?
correct.
Again, are these more seals?
Yes,
And were any of them broken?
no,
What are we looking at here?
this is the front driver's seat of the white Cadillac.
In here?
Again, the front driver's seat of the white Cadillac and the floorboard.
And here?
That is the rear driver's side. That is the front passenger side. And that is the trunk.
Okay. And did you collect this bag, this blue with white polka dots bag?
Yes,
Okay. And was there evidence contained in that bag?
yes.
Can you tell the ladies and gentlemen of the jury what was contained in that bag that you collected?
It contained a black neoprene mask, a black cloth mask, 6 Aquila, which are labeled with an A on the head stamp cartridges that were inside of a cardboard box.
I'm going to stop you right there for a second so we can go over those first.
Sure.
All right. Showing defense counsel what's been previously marked as state's QQ for identification. Commissioner, approach the witness, Your Honor.
You may.
Detective, I'm showing you what's been previously marked as state's QQ for identification. Do you recognize it?
Yes.
And how do you recognize it?
It has my packaging, and that is the blue and red Jordan bag.
Okay, and again, your packaging is the brown bag, correct?
Correct.
And besides the presentation, clear plastic around it, has this been altered in any way, or is it the same or substantially the same as it was when you collected it?
It's the same as it was when I collected.
All right, Your Honor, at this time, the state would enter into evidence what's been previously marked as state's QQ of state's 43.
No objection.
No objection.
No objection.
Without objection, what was previously marked states double Q for identification shall be received in evidence of states 43. You may publish at will.
I have permission to hand it to the jury, Your Honor.
You may.
Detective. So, talk to me about those masks you just mentioned.
So inside of that bag, there were 2 black masks. One was more of a cloth material, and one was more of a, what we refer to as a neoprene material, kind of more foam type.
Okay. Showing defense counsel what's been previously marked as states RR and SS. May I approach the witness, Your Honor?
You may.
Detective, I'm now showing you what's been previously marked as states RR and states SS for identification. Can you take a look inside?
Do I pull them up?
If you need to be able to see it fully, yes.
Yep. This is the neoprene mask, and this is the cloth mask I collected.
Now I see that.
Refer to which, when you say this.
Sure.
Okay, so SS, which one is that?
SS is the neoprene mask,
Thank you.
And RR is the cloth?
and RR is the cloth mask.
All right, so I see that the bags are open, unlike some of the other packages that we've already seen earlier. Why are they open?
It's so that the jury can see them and take a look at them.
Okay, so-
There's nothing biohazard on them, so that they're able to be looked at.
And were the masks placed on mannequin heads, I should say, in order to present them to the jury here today?
Yes, so they can see them better.
Other than being placed on those mannequin heads that we see in there, are they in the same or substantially same condition as they were when you found them in that bag that we see here on the screen?
Yes.
Yeah. Your Honor, at this time, the state would enter into evidence what's been previously marked as states SS and RR as 44 and 45.
No objection. No objection. No objection.
Without objection, what was previously marked states RR and SS for identification shall be received in evidence as states 44 and 45 respectively.
Permission to publish, Your Honor.
You may.
Now, Detective, you also mentioned in that bag we see on the screen some Anguilla ammunition, correct?
Yes.
All right. And can you tell me about all the Anguilla ammunition that you collected?
Objection.
You may.
Noted.
There were multiple boxes of the Aguila, which is a .22 caliber ammunition.
Okay. And did you collect all of that?
Yes. The Aguila ammunition has a A on the headstand.
All right. Showing defense counsel has been marked as states TT. Commissioner approach. Getting my steps in today. All right. I'm showing you it's been marked as states TT for identification. Do you recognize it?
Yes.
And how do you recognize it?
This is all of my packaging, and this is all the evidence I collected.
Okay, so this is the Anguilla .22 caliber ammunition?
Yes.
Okay, and has it been packaged for jury presentation?
Yes, so it was put into these white boxes, which were then sealed and then put into these brown paper bags. But for courtroom presentation, we put them in the plastic, clear plastic, and then also on this styrofoam so that you can see it pulled out.
And besides the jury presentation of this, has it been altered in any way, or is it fairly or substantially the same the way it was when you collected it?
It's the same.
Your Honor, at this time, the state would enter into evidence that's been previously marked as states TT, as states, losing track, 46.
No objection. No objection. No objection.
Was previously marked states double T for identification shall be received as evidence as states 46. You may publish.
Thank you, Your Honor. And permission for the witness to step down, Your Honor, as I'm going to have him open some of this to show. Do you need gloves, detective, or no?
No, there isn't.
Okay. All right, so walk us through, after you see the middle so everyone can see. This, we'll start from left to right.
So these are the boxes that the ammunition was in, and they are 22 caliber Aguila brand.
Okay. And is that the packaging that we see next to it?
Correct. This is my bag that I placed this box into.
All right. Same with this one as well, the next one?
Same with that one.
And then here.
These are the cartridges themselves. Those 5 that were put into the bottom of the styrofoam were taken from that top box. And again, that's so that you could take them out, you can look at them and see the head stamp.
And the head stamp has an A, correct?
It has an A.
Right.
The letter A.
And all these boxes, were they also filled with Aguila ammunition?
Yes.
And you could take some out and just show them to the jury. You may have a seat. Thank you. Were these those Anguilla, or I'm pronouncing it wrong, but the ammunition that you were discussing?
Yes.
Okay. And there's 3 boxes of these that you have packaged in here?
Yes.
Okay, and what are we looking at here?
So again, this is when we first opened the blue and red Jordan bag, and those were the masks as they were found.
And did you also document photographing the masks as well?
Correct. That is the neoprene mask, and then this one is the cloth mask.
And do you also photograph, obviously, the ammunition we just saw?
Right, that's the same boxes that you see over there.
And are these the boxes opened and seeing what was inside?
Correct.
Same as before?
Yes.
Another box opened? Okay, and what's in here?
That is a Just for Sports bag. It has clothing items.
And were these the items of clothing that you found in that Just for Sports bag?
Yes.
And did they have tags on them?
Yes.
And what are we looking at here?
It's a pair of black gloves.
And here?
There's paperwork from the glove compartment.
And what does it say on the paperwork that you found in the glove compartment?
Michael Boatwright.
And what are we looking at here?
This is a picture of a latent print. I processed the vehicle for latents, and I took a picture of it so they were able to see where that it came from.
Now, the jury heard a little bit about latent prints yesterday, but can you explain your process of how you went about processing those particular prints?
So in this situation, I used the standard method of using black powder and a brush, and I brushed for fingerprints, and then I lifted them with tape.
Okay, now, are there other ways to also do that?
Yes, we can super glue a car, I believe. That was what a different car was used with. There's different methods that we can use. This is mostly the standard method that we use is fingerprinting with black powder and lifting that fingerprint.
Okay, so in fact, you did lift this fingerprint?
Yes, I documented it in the chance that if I had lifted it and there was something wrong with it, that we would have a photographed image of it that could be submitted. But we lifted it and it came out good on the lift, so we submitted the lift itself.
And is that a close-up of it?
Yes.
And what about here?
Yeah, it's like an intermediate kind of close-up of the area. And that is the item number that I gave it.
Okay.
The arrows to show which way it's up. So in this particular instance, it's relatively easy because it's the door handle, but depending on the situation time and the closeness of the photo, it sometimes can be hard to tell which way is up. So we usually will put an arrow inside of it to show which way is up.
And you said besides documenting it in photograph, you also actually lifted it with tape, correct?
Yes.
Walk us through that process for us.
So I will use a brush and black powder, and I will black powder the area around it, and then when I visually am able to see a fingerprint, I will take clear tape and I will place it on there and then physically peel off the fingerprint itself and put it onto a piece of white cardboard stuff or white paper. And then that gets submitted to the latent unit for identification.
Showing defense counsel with some previously marked estates VV for identification. May I approach witness, Your Honor?
Ma'am, you may.
Detective, I'm showing you with some previously marked estates VV for identification. Can you take a look at that?
Yes.
Do you recognize it?
Yes.
And what is it?
It is the latent lift that I collected from the car.
From the tape that you just described?
Yes.
Okay. And are these prints, in the lifted prints, or latent prints, I should say, in the same or substantially same condition as they were when you originally collected it?
Yes.
Your Honor, at this time, the state would enter into evidence with some previously marked estates VV for identification, estates 47.
No objection.
No objection.
No objection.
Whose previously marked states VV for evidence for ID shall be received in evidence as states 47. You may publish.
Detective, have you opened it? Sean, and this green sticker, what does that mean again?
That's from the lab.
Now, getting back to the vehicle really quickly, what are we looking at here? Is this post-processing the vehicle?
Yes, this is post-processing, and then I added a new set of evidence seals.
And same initials and date as it was before?
Right, correct. So you can see the lower seal with the white on it was the original seals that I had, and then the newer seal that was all red, those were the later seals that I placed on there.
So the broken one is the old one, and then the top one is the new one?
Correct. To reseal the vehicle in case it needs to be processed again, or they wanted to look at it again. It was 6.
Now I want to get back to those masks for a second. I'm just going to pull one out for demonstrative purposes from states SS, which is now states 45, the neoprene mask. Now, besides collecting these masks, did you also process them for DNA?
Yes.
How did you go about doing that?
So I swabbed the interior portion of the mask where things like saliva and stuff like that would collect. And I swabbed the interior of it with the same 2 cotton swabs and sterile water that we use to swab it.
Okay, and did you also do it on the cloth mask, which is the 44?
Yes, using the same process.
Same process?
Yes.
Around the mouth?
Correct, around the mouth area where DNA and skin cells would collect.
Showing defense counsel which was previously marked as states UU for identification. Permission to approach witness, Your Honor.
You may.
Detective, I'm now showing you what's been previously marked as states UU for identification. Can you take a look at it?
Yes.
Do you recognize it?
Yes.
And how do you recognize it?
This is my packaging, and these are the swabs of the mask.
And are they fairly inaccurate? Are they in the same or substantially same condition that they were back when you swabbed them originally?
Yes.
Your Honor, at this time, the state would enter into evidence what's been previously marked as state's exhibit UU for identification.
No objection. No objection. No objection.
States 48.
What was previously marked states U for identification shall be received without objection as states 48.
And as they are biohazard, I will not open them, Your Honor.
Understood.
Is that your name and badge number?
Yes.
And then is that green seal from the lab that we've seen previously?
Yes, that is the lab number.
And then what is this white and black label underneath?
Those are the barcodes that are placed there by evidence control, so the warehouse. So, and again, that's just so they can track it.
And the date, is that 7/7/18 of when they're swabbed?
Yes.
Leave it in there? I have no further questions for this witness, Your Honor.
Cross?
Just give a 5-minute conference break.
Okay, jurors wanted, so, right.
Jurors are entering.
Parties may be seated. Court will come to order. The parties are present. Jurors are present. Ladies and gentlemen, welcome back. Cross-exam on behalf of Mr. Boatwright.
Yes, thank you, Judge.
You may.
Good afternoon, sir.
Good afternoon.
I want to start back at the hospital. When you tell the jury again a little bit more about when you go to the hospital, there is a deceased victim there. What is it that you are trying to do? What is your goal there?
My goal is to document the victim and collect any and all evidence that are pertinent to the case.
Okay. And you know that this victim has been murdered, correct?
Yes.
All right. So in collecting any evidence that may be pertinent to the case, you're hoping to collect evidence to identify suspects in the case, correct?
Yes.
You indicated that you swabbed a number of areas right at the hospital to help effectuate that, correct?
Yes.
All right. I want to talk about those swabs and what ends up, where those swabs end up going. All right. So, am I correct that when you swab something and then you collect it, that you give it a label, a label that includes some letters and a number?
Yes.
And in this case, the pieces of evidence that you swabbed from Mr. Onfroy, you labeled them as JO 1 through however many you did, correct?
Correct.
JO, I assume, stood for Jose Onfroy?
Yes.
Okay. So I want to talk about those. You identified you took a swab or you took two swabs that you ended up labeling as JO1, correct?
Yes.
Can you tell the jury what those were, please?
So JO1 was the swabs of his left fingernails.
And it was two swabs of his left fingernails, correct?
Yes. So anytime I swab something, I always again use two swabs, and both of those swabs go into one box.
Left fingernails, are we talking about all 5 fingernails?
Yes.
And when you swab the fingernails, am I correct that you're swabbing underneath the fingernails?
Yes.
Why are you doing that?
If the person that came in contact with the defendant or the suspects, they could possibly be defending themselves or trying to grab onto them. So that is the area that the person's DNA would like to collect.
In this case, you actually had evidence that Mr. Onfroy was in fact may have been engaging with the suspects in the case, correct?
Yes.
You collected swabs and labeled them JO2, correct?
Yes.
And can you tell the jury, please, what those swabs were?
Those are the swabs of the right fingernails.
Again, there was 2 swabs in the right fingernails?
Right. 2 swabs of the right fingernails.
And again, those swabs, you swabbed underneath all 5 fingers, or excuse me, underneath all 5 of Mr. Onfroy's fingernails?
Yes.
Correct? And you took some swabs that you identified as JO3, correct?
Yes.
Can you tell the jury what those swabs were, please?
Those are swabs of his neck.
Again, 2 swabs of Mr. Onfroy's neck?
2 swabs of his neck.
Can you tell the jury, please, why you took 2 swabs of Mr. Onfroy's neck?
Because he had the gold metal chain on, and if somebody had grabbed in that general area, then again, there would be likely a possible DNA transfer onto his neck. So we swabbed that area.
You would agree, you testified a little bit about what doctors typically do in these types of situations. You talked about how they would cut some of the clothes off and put that off to the side, correct?
Yes.
Would you agree with me that ER doctors are typically wearing gloves themselves?
Yes.
And JO1, JO2, and JO3. So the 2 swabs of the left fingernails, 2 swabs of the right fingernails, 2 swabs of the neck. That is what has been introduced by the state as states 39. Is that correct?
Yes.
All right. And so those swabs are inside this envelope right now, correct?
Yes, inside of that brown paper bag are the same white envelopes that you saw the other ones. Those envelopes contain the boxes that contain the swabs.
Thank you. When you are... Yesterday we heard a little bit about what happens to evidence when you guys are done with it. You would agree with me that some evidence that you collect, you take to or get sent to the crime lab, correct?
Yes.
You would agree with me that some evidence that you collect ends up going to a warehouse, a BSO warehouse, correct?
Yes.
And you would agree with me that some evidence you just give directly to another detective and they do whatever they do with it, correct?
Yes.
In this case, JO1, the 2 swabs of the left fingernails, can you tell the jury, please, where JO1 was sent to?
It was sent to the lab.
And can you tell the jury, please, where JO2 was sent to?
It was sent to the lab.
And can you tell the jury, please, where JO3 was sent to?
It was sent to the lab.
And the lab, more specifically, am I correct that these were sent to the DNA section of the laboratory?
Yes.
Am I correct that you, from the hospital, took in a piece of evidence that you labeled as JO8?
Yes.
Can you tell the jury, please, what that was?
That is the yellow metal necklace.
And that is the same metal necklace that has been introduced into evidence as states 38, correct?
Yes.
Am I correct that you, well, let me back up a second. When you take the necklace into evidence, you put it into this brown paper bag, correct?
Yes.
And you seal the paper bag, correct?
Yes.
All right. And the purpose of one of the purposes of doing that, am I correct, is to try to ensure that the necklace doesn't have contact with other people or any other items that might have other DNA on it, correct?
Correct.
Okay. You've heard of the term DNA transfer before?
Yes.
Can you tell the jury a little bit about what that is?
It's simply that if there's some DNA on one item and it touches another item, that DNA can be transferred from the one item to the other.
All right. So if I were to take this out of the bag and grab it with my hand, there is that would create the possibility of my DNA ending up on the necklace, correct?
Correct.
Am I correct that you obtained in items of evidence that you labeled JO8A.
Yes.
Can you tell the jury, please, what those were?
There's 2 swabs of the necklace.
And again, you're just taking the swabs and you're essentially rubbing the necklace with the swabs, correct?
Correct.
And the hope there is that if there is DNA on the necklace, that you capture it with the swab, correct?
Correct.
Am I correct that you also collected an item that you labeled as JO9 into evidence in this case?
Yes.
And can you tell the jury, please, what that was?
That is a white metal earring.
And that was a, I don't know if earring has 1 R or 2s. I'm going to go with 2. Is that an earring? That's an earring that was identified as having been in the ear of Mr. Onfroy?
Yes.
Let's talk about where these items go. Can you tell the jury, please, in 2018, where did you send JO8?
I sent it to evidence control.
Evidence control being?
The warehouse where we store evidence.
Thank you. And can you tell the jury, please, where you sent JO8A, which is also showing you states 39?
I sent the swabs of the necklace to the lab.
And can you tell the jury, please, where you sent JO9?
They were sent to the warehouse.
Between 2018 and 2022, or excuse me, 2023, at any time was a decision ever made to send JO8 or JO9 to the lab?
We don't typically send items of evidence to the lab. We process those items, like for example for DNA, and then the DNA swab gets sent to the lab. The items themselves are usually never sent to the lab themselves.
So the answer is no, correct?
No.
All right. And the metal earrings there at the warehouse, they remain at the warehouse today, correct?
Correct.
The metal earring. Okay. Let's talk a little bit about the search of at 1617 Northwest 15th Street. That was on July 6th of 2018, correct?
Yeah, I have it written in our report.
You can refresh your recollection.
Yes, July 6th.
All right, so that would have been, if the homicide was on June 18th, that would have been 18 days after the homicide, correct?
It was, yeah, that amount of time.
I want to ask you a couple of questions about a couple of pictures. We have shown you one of the pictures that is in States 42. These were shoes that you photographed, correct?
Yes.
Did you actually take these shoes into evidence?
I took several pieces of evidence, items into evidence. I don't know if those shoes are in evidence or not.
Did you swab these shoes at all?
No.
There is a we see a pair of black pants here, correct?
Yes.
Did you take these black pants into evidence?
Yes.
Did you swab these black pants at all?
No.
There's a pair of camo shorts here. Did you take these camo shorts into evidence?
Yes.
Did you swab these camo shorts at all?
No.
We have a second pair of black pants. Did you take these black pants into evidence?
Yes.
Did you swab these black pants at all?
No.
Going back to the first pair of black pants. Those black pants are taken into evidence. Where do those black pants end up?
The warehouse.
And they remain at the warehouse today?
Yes.
Same with the camo shorts. Where do the camo shorts end up?
The warehouse.
They remain at the warehouse today?
Yes.
And these black pants, where do those black pants end up?
The warehouse.
And they remain at the warehouse today?
Yes.
You did not label any of these pieces. Let me ask you a better way. Did you label these black pants with the letter and number identifier like we talked about before?
Yes.
Okay. Can you tell the jury, please, what that is? What that identifier was, please?
I don't have those particular ones. Hold on one second. So those would be labeled with BSW. So lower right search warrant. So BSW 1 through, this one is 1 through 5. There's 4A, 4B, and 4C because those are things that were collected from inside of those jeans.
And specifically, these jeans is BSW. What's the number?
Those are the Smoke Rise jeans. Those are BSW 3, collected from the northeast bedroom.
And that was, again, these are at the warehouse, correct?
Yes.
The camo shorts, can you tell us what the label that you gave those are?
BSW 2.
And those are at the warehouse, correct?
Yes.
And these black jeans, how did you identify these?
Those are the Smoke Rise brand jeans.
Thought BSW 3 was.
Yeah, those are the same jeans. It's just that one was laying down, and the other one it's being held up.
Okay, perfect. So same thing. That's still BSW 3, correct?
Right. Yeah, exactly. One picture's laying down. The other one is being held up.
And the shoes, we're not sure if these shoes were taken into evidence or not.
Those are the BSW 1. Those are the 2 black Nike sneakers collected from Northeast Bedroom.
Okay, perfect. So they were.
Yeah, BSW 1.
And they call them their Nike sneakers?
Yes, the black Nike sneakers collected from Northeast Bedroom.
And where did those sneakers go?
The warehouse.
None of these items were swapped, correct?
Correct.
All right. Showing you another pair of jeans that were found outside the residence. Did you take these jeans into evidence?
Yes.
And how did you label these jeans?
BSW 4.
How did you give him how did you describe them?
Black jeans, Levi's brand collected from outside trash bin.
Levi, outside. Where did these jeans go?
The warehouse.
And did you take any swabs of these?
No.
Okay, let's talk now about the Cadillac. Cadillac gets taken from the home to the garage at BSO, correct?
Yes.
And am I correct that one of the things that you do is you take a number of swabs from the inside of the Cadillac itself?
Yes.
Am I correct that the purpose of that is to try to identify people who may have been inside that Cadillac?
Correct.
Let's talk about those swabs. Those swabs you identified as WCS 1 through 5, correct?
Correct.
What does WCS stand for?
And it'd be white Cadillac swab 1. And
Perfect. So WCS 1, can you describe where those swabs came from, please?
that's the front driver's side armrest.
In all of these instances, it's 2 swabs from the same area, correct?
Correct.
2 swabs from driver seat armrest. Come on, there we go. You identified some more swabs as WCS2, correct?
Yes.
Where do those swabs come from?
That would be the front passenger side armrest.
WCS3, you identified some swabs and labeled them WCS3, correct?
Correct.
Where do those swabs come from?
The steering wheel and gear shift.
WCS4, can you tell the jury where those swabs came from, please?
The center console.
And WCS5, can you tell the jury where those swabs came from, please?
The interior trunk lid.
Why did you swab the interior of the trunk lid?
Because there was items of evidence that were collected from inside of the trunk.
Okay. And so you were hoping to identify people who may have had access to that trunk, correct?
Correct.
Can you tell the jury, please, where WCS1 ended up?
The warehouse.
Tell the jury where WCS2 ended up.
The warehouse.
Tell the jury where WCS3 ended up.
The warehouse.
Tell the jury where WCS4 ended up.
The warehouse.
And can you tell the jury where WCS5 5 the swabs from the interior trunk lid ended up?
The warehouse.
At any time between 2018 and today, were any of those swabs delivered from the warehouse to the crime lab?
No.
Those swabs, do those swabs remain at the warehouse today?
Yes.
You also were able to lift what appeared to be a fingerprint, correct?
Yes.
And that was from, you labeled that WCP1, correct? I'm sorry, I didn't hear you.
Correct.
And that's what's been introduced into as States 47, correct?
Yes.
And can you describe for us again where you lifted that fingerprint from?
That was above the driver door handle.
And can you tell the jury, please, where that latent ends up?
That went to the latent identification section of the lab.
The latent identification section is where fingerprints or suspected fingerprints that are lifted from scenes are sent, and they're compared to known prints by the analysts there, correct?
Correct.
That's where analysts see if a fingerprint is a match to somebody, correct?
Yes.
You don't have anything to do with analyzing prints at the lab, correct?
No.
You don't have anything to do with analyzing swabs to see if there's DNA there, correct?
Correct.
Let's talk a little bit about some items that were obtained from the trunk. And I'm going to start with this one. You observed and obtained a Just for Sports bag from the trunk of this Cadillac, correct?
Yes.
At the time, were you aware that someone named Dedrick Williams had been arrested already in this case?
I don't recall if this was before or after.
Were you aware that there was evidence that Mr. Williams had visited a Just for Sports the day after the homicide?
At the time, I can't tell you whether I was aware. I'm aware of it now, but I don't know if it was at that moment. No.
This Just for Sports bag, you seized this, or you took this into evidence, correct?
Yes.
How did you label the Just for Sports bag?
That would be WC19, which had 26 items inside of it.
Going back to the photos in States 42, this is a photo of the inside of the trunk, correct?
Yes.
This is the blue and red Jordan bag you referred to earlier that we've seen introduced into evidence, correct?
Yes.
You took this, you obviously took this into evidence, correct?
Yes.
All right. How did you label the blue and red Jordan bag?
I believe it was WC1. Yes, it's WC1.
We're going to talk a little bit about the masks you found in a second. At any time while you were looking in this Cadillac, did you see a red mask?
No.
Did you ever see a red mask at Mr. Boatwright's, when you were searching in Mr. Boatwright's home?
No.
Throughout the entirety of your involvement in this case, did you ever find a red mask?
No.
You identified something, or there are a few pieces of ammunition, 6 pieces of ammunition here that you seized from the Cadillac, correct?
Correct.
And you labeled that as WC4, correct?
Yes.
I guess I should have asked you how you identified it. I've identified it as 6 .22 caliber Aguila cartridges. Is that a fair description of what is contained in WC4?
WC4 is 6 .22 caliber Aguila cartridges collected from the blue-red Jordan bag.
Cartridges. Can you describe for the jury, please, somebody that doesn't do your work, I think of bullets, or we've heard the word projectile. Can you describe for the jury, please, what you mean when you say cartridge?
Yeah, so a cartridge is the thing as a whole, right? So the projectile is the part that actually leaves the barrel and physically gets shot out. The fired casing is just the metallic part that holds the gunpowder and everything. When it's all together as one, we refer to it as a cartridge or a live cartridge or a live round. But so that we don't have a bunch of different terms, we all try to use the same terminology. So cartridge just means the whole thing as one. Projectile is the actual physical bullet that leaves. And a fired casing is just the casing that gets ejected out and is usually on the ground when we look at it.
And everything that was found in the trunk of this Cadillac was a cartridge, correct?
Correct.
There was no spent casings, correct?
There was no casing.
And there was no projectiles. There were no projectiles, correct?
There were no projectiles.
Okay. And so with just the cartridges, am I correct that you didn't send any of these cartridges to the crime lab, correct?
Correct.
There would be no reason to send these cartridges to the firearms section of the crime lab, correct?
Correct.
Tell the jury why.
Because if they are just a cartridge from the box or they haven't been used yet, there wouldn't be any identifying markings on them. The only reason that a cartridge would have identifying marking is if it was inside of a gun and then cycled out, and that would leave maybe a slight mark on there sometimes. But in these situations, these were just boxes of ammunition that were unused, so they weren't sent to the lab.
You identified something as WC4A, correct?
Correct.
Can you tell the jury what that was, please?
That is the box itself. So I identified the 6 cartridges that were inside of that box as WC4, and WC4A was the box because I had also processed those boxes.
When you say you processed those boxes, what do you mean by that?
I processed them for latent fingerprints using chemicals and things of that nature. There were none on there. So using a cardboard box, we would usually use an hydrant which is a chemical that you can get fingerprints off of paper with. So these cardboard boxes were sprayed with anhydrine. There were no fingerprints that were obtained from them.
Tell me how, can you give me there are a couple boxes that we see here. Is there a way that you specified this particular box in WC4A?
Yeah, it's a Guila cardboard box collected from Blue Red Jordan bag.
You indicated that you attempted to get prints off of this box, correct?
Correct.
But there were no fingerprints on the box, correct?
I was not able to obtain fingerprints from the box.
Okay. Prints attempted. You identified something as WC5, correct?
Correct.
Can you tell the jury what that was, please?
That was the 40 Aguila 22 caliber cartridges.
Same question as before. None of these are fired projectiles, correct?
No.
None of these are casings, correct?
Correct.
Can you tell, did you identify something as WC5A?
Yes, that was the cardboard box collected from the Blue Red Jordan bag. So that was the box that the 40 Aguilas were collected from.
Gotcha. Cardboard box containing 40 cartridges.
Yes.
Did you attempt to obtain any latent fingerprints off of this box?
Yes.
Were you successful?
No.
Am I correct in going back to the trunk, there's a gray sheet that you seized here, correct?
Yes, there's a gray sheet in the trunk.
Okay. And you took that into evidence, correct?
I'm not sure if that was taken into evidence.
Did you take it into evidence under WC 21?
Yes, sir. WC1, gray sheet.
WC 21?
No, excuse me. Yes, WC21, gray sheet collected from trunk.
In the back seat of this vehicle, am I correct? There were two red Solo cups.
Correct.
Back there, and you took those into evidence, correct?
Correct.
And did you label? How did you label those?
It's WC26, 2 red plastic cups collected from your folder.
And there was another cup that you found in the Cadillac as well, a clear plastic cup, correct?
Yes, WC27. That was from the front passenger floorboard.
All right, let's go one by one to where these items ended up. WC19, we see it in evidence now. Where has it been since it was collected in 2018?
At the warehouse.
WC1, the blue-red Jordan bag. I'm sorry, I back up. The Just for Sports bag is not in evidence. We have not seen that today, correct?
We have not seen that today, no.
Okay, that Just for Sports bag is still in the warehouse today, correct?
Yes.
Okay. The blue-red Jordan bag we have seen in evidence. Where has that been since 2018?
In the warehouse.
Did you ever swab the Just for Sports bag?
No.
Did you swab any of the items inside the Just for Sports bag?
No.
Did you swab this Blu-ray Jordan bag?
No.
WC4, the 6 Aguila cartridges, where have those been since 2018?
At evidence control, at the warehouse.
Did you ever swab these cartridges for DNA?
No, they were processed for latent prints using super glue with negative results as well.
Okay, so you attempted fingerprints, but not DNA. Am I
Correct.
hearing you correctly? Swabs. Attempted prints. WC4A, the cardboard box. Where has that been since 2018?
The warehouse.
Did you swab the box for DNA?
No.
WC5, the 40 cartridges. Where have those been since 2018?
The warehouse.
Did you swab any of those for DNA?
No.
WC5A, the cardboard box containing those 40 cartridges. Where have those been since 2018?
The warehouse.
Did you swab any of those for DNA?
No. Just on your previous one before you complete, prints were attempted on those as well with negative.
WC5.
WC5.
Okay, thank you for clarifying that. Prints were attempted and none were found?
Correct.
Okay. WC21, the gray sheet, where has that been?
Evidence control, the warehouse.
Any swabs of the gray sheet?
No.
The 2 red solo cups, where have those been since 2018?
The warehouse.
Any swabs of those?
No.
And the clear plastic cup, where have those been since 2018?
The warehouse.
Any swab of that?
No.
We talked a little bit about DNA, about how DNA is transferred from one item or from one person to another. If I touch something with my hand, that creates the potential that there will be DNA on that item, correct?
Correct.
If I, some surfaces, am I correct that some surfaces are more perceptible to having DNA on them than others?
Yes.
Describe that a little bit for me.
Some things that you touch, you leave a certain amount of DNA on, and you could theoretically leave more if it's a different type of surface. It just depends on whether it's cloth, or whether it's something that's hard or rough, something that's more slick like this. You're going to leave more or less depending on the surface.
And am I correct that items can transfer DNA from one to another?
Yes.
Like you don't, when you seize pieces of evidence, you don't put them together in the same bag, correct?
No, we package them in separate bags.
Okay, and that's because DNA you want to avoid DNA on one item transferring from transferring to another item, correct?
Correct.
So these masks, if I were to hold these masks with my bare hands, that would create the potential for transferring DNA to the mask, correct?
Yes, you could leave your DNA by holding it with your hands.
Same with this mask. If I were to hold this with my bare hand, that would create the potential to transfer DNA to the mask, correct?
Correct.
When you collected the masks, you put them in their own individual bags, correct?
Yes.
You didn't put any other items in those bags with them, correct?
No.
Because you didn't want to, you wanted to make sure that there was no transfer of DNA between items, correct?
Correct.
Just have a moment, please, Judge. Thank you, Judge.
Thank you. Cross on behalf of Mr. Newsom.
Yes, sir. Good afternoon, Detective Walcott.
Good afternoon.
Detective Walcott, you were present at a search of the Boatwright residence, correct?
Yes.
Were you present at the search of Mr. Newsom's residence?
No.
When the DNA swab of Mr. Newsom was taken for comparison, were you present there after he voluntarily surrendered to law enforcement at my office?
No.
Now, DNA generally is found in all cells of the human body, correct?
Yes.
Okay. Now, there may be certain types of transfer of DNA that makes it more likely you could detect it, such as blood, correct?
Yes.
Blood is full of DNA, and if you leave blood somewhere, it's likely going to have DNA that you're going to be able to test, correct?
Yes.
Saliva also. Isn't that true?
Yes.
Okay. And that, I would imagine, is the reason you indicated that you swabbed the mouth area of these two masks.
Correct.
Because in your opinion, and likely your experience, DNA's transfer from saliva is more likely than simply touching an item where skin cells can be exfoliated from the body and you can find DNA that way.
Correct.
Okay. But am I correct that a mask that's around the head, touching skin quite tightly apparently from looking at them, also could have had DNA in different places on it?
Yes.
But the most likely place is around the mouth, and that's why you tested it there.
Yes.
Now, you testified to something quite important. You indicated that at the time you went to the hospital to collect that necklace, let me go get it. You and other law enforcement officers already knew that this may be a very important piece of evidence in the case, correct?
Yes.
Because not only did you have witness testimony that the assailants in this case were trying to grab that necklace, there was video that showed them trying to grab the necklace, correct?
Correct.
And again, common sense would say that if you're targeting someone for robbery to get something valuable from them, that necklace would be a place that you would go to try to grab, correct?
Correct.
Now, you've indicated also that some surfaces you're more likely to deposit the skin cells from touching than others, correct?
Yes.
And if the necklace was worn out with just the gold side, you could get DNA on that from touching it, correct?
Yes.
But with all of these tiny diamond chips here, because the diamonds are sharp and abrasive, you'd be more likely to transfer DNA from someone touching it because of the abrasive nature of that side of the necklace, correct?
It could, yes.
Okay. One more thing about the necklace. It's clear when you look at it in person, and we couldn't see it as well in the photograph, but now that we see it, there's a little bit of blood on this necklace, correct?
There's blood on the necklace.
Okay. This wasn't drenched in blood, was it?
It's exactly as you see it there.
Right. So at the hospital, when you've gone to many of these unfortunate situations where someone has been shot and the hospital technicians are using gloves, removing things from the body, also making sure they don't contaminate evidence, correct?
Correct.
Because they're all trained that that's a bad thing to do, right? We got to be careful with this stuff.
Correct.
They wouldn't have washed that clean, would they?
No.
So that's, as far as we know, as close to the exact condition it was in when it was removed from the body as possible.
Yes.
Okay. You also had an important piece of information, law enforcement did, about masks being involved in this case, correct?
Yes.
And again, because there's live witnesses that saw the assailant using masks, correct?
Correct.
And again, you look at the video and it's pretty obvious that their faces are covered by masks that could have been either of those two masks right there. Fair enough?
Fair enough.
So obviously they were swabbed in your in the manner in which you've been trained through your many years of experience and training to get as much DNA from them as you possibly could.
Yes.
To make a comparison later. Now, you'd agree with me that DNA is an extremely important tool for law enforcement.
Yes.
Let's give you a hypothetical. Let's say you're investigating a burglary. Someone breaks a window and breaks into someone's house. But they've cut themselves, obviously, and there's some blood right there on the jagged glass. You're going to swab that blood, aren't you?
Yes.
You're going to send it to the lab for testing, aren't you?
Yes.
And you're going to be able to identify from that DNA the source if you have someone to match it up to.
Correct.
Okay. So hypothetically, let's say someone gets arrested because the homeowner thinks they look like someone that was hanging around their house right before the burglary. A suspect. You're going to swab them for DNA, correct?
Yes.
And you're going to test that DNA. Of course, right?
Yes.
If the DNA matches, you got the guy, don't you?
Yes.
If it doesn't match, it's a bad identification, correct? Because the person that did it obviously left the blood there.
I follow.
Gotcha. So it can be used to eliminate suspects as much as it can be used to incriminate suspects, correct?
Correct.
And how long does DNA remain testable?
DNA remains on there for years and years afterwards.
Years and years. And the DNA that may or may not be on objects that went to the warehouse would still be there, would it not?
There's still DNA there. Yes.
In fact, DNA has been tested from decades ago and resulted in the arrest of suspects many decades later when it's matched up to an individual who finally is forced to give law enforcement a sample of their DNA for whatever their contact with law enforcement may be.
Yes.
Correct? And cold cases are solved on the basis of DNA all the time.
Objection, Your Honor, outside the scope.
I'll give it some line.
And in fact, that was the last question I had. And Detective Walcott, thank you so much for your testimony. Thank you, Your Honor.
Cross on behalf of Mr. Williams.
Good afternoon.
Good afternoon.
So, you've testified that DNA can stay on items for years, correct?
Yes.
So hypothetically, if I were to be, which I actually do like to snowboard, if I'm wearing a mask snowboarding, let's say, right, and I lend it to you, and you go the next season and you wear the mask, and then eventually the mask is tested a year later, it could have both our DNA. That's possible?
Yes, it's possible both the DNAs could be on us.
No further questions.
Reed?
Yes, Your Honor. All right, Detective. We got some things to talk about here. You were asked about all the swabs you took in this case, correct?
Correct.
And you recall Mr. Kimmock asking you about the swabs that you didn't take on certain items, correct?
Correct.
Now, you're getting this information how quickly after the homicide happens?
What information?
About the case, about what you need to know in order to do these swabs.
As I'm in the investigation, I'm getting information.
Okay. Do you recall what time the homicide was called into law enforcement?
I don't have that off the top of my head.
Would a police report refresh your recollection?
Yes.
Okay. Showing Foster's report, page 53. May I approach witness?
May.
Please refresh your recollection. Look up when you're done.
So it says deputies were dispatched at 3:57 p.m.
Okay. So when that homicide occurs, or a shooting occurs at this point that we know about, how fast do deputies respond to a shooting?
Immediately.
Objection calls for speculation and hearsay, calls for hearsay.
Oh,
How fast?
Immediately.
Immediately. Okay, and how long after 3:57 p.m. when this call came in did you respond to the hospital?
I responded to the hospital at 16:20, so 4:20,
4:20. Okay.
and
So-
I arrived at 5 o'clock.
And you arrived at 5 o'clock. So pretty fast afterwards, correct?
Correct.
And the victim is already dead at that point when you arrived at the hospital?
Yes.
And you're getting information over the phone as it's coming in, right?
Correct.
Fair to say that investigations are continuously unfolding and you learn more information as the days go by?
Objection, leading.
rephrase.
Do you learn more information about the case as the days go by within an investigation?
Yeah, these cases are always ongoing, and we're constantly getting new information.
But at the time you're documenting the victim's lifeless body, you have to work with what you already know, correct?
Correct.
So about an hour's worth of information, right?
Correct.
Okay. Do you swap places on the victim or the victim's clothing or jewelry in an abundance of caution?
Yes.
Do you always get DNA off of things that you swab?
No.
Are you trained to swab certain things and not swab certain things based on the type of item it is?
Yes.
Can you give us some examples?
Certain items I'm going to swab because they are more conducive. Certain items I'm going to process for fingerprints because they are more conducive for getting fingerprints off of versus getting DNA. And that's just based on training and experience and know what I'm going to possibly get a better DNA or better fingerprints or what have you from it.
How do you make the decision as to whether to process something for DNA or for fingerprints?
It has to do with whether I can actually obtain fingerprints off of it. So I can obtain fingerprints off of smooth surfaces, paper, things of that nature. But a piece of cloth, I'm not going to be able to get a fingerprint off of because you're not going to be able to see the friction-rich detail on it.
All right. Now, you were also asked about why this necklace wasn't sent to the lab, correct? You remember that by Mr. Kimmock?
Correct.
Why don't we send this to the lab?
We don't send any items to the lab. Again, we process the items for DNA, swab it, and then I send the swab to the lab. The item itself never gets sent unless the DNA analyst specifically requests it, which is a very rare case.
Okay. Now, detective, just because I touch something, does that mean I'm going to leave a fingerprint?
No.
Just because I'm touching all these items? No? Just because I touch it, am I going to leave DNA that you would be able to test later on?
Yes, you probably left some amount of DNA.
But would we know if we would get a full profile to identify someone?
No.
Okay. What do I mean by that? Can you explain that to the jury?
So,
full profile.
So when you have DNA, right, let's say you left some skin cells or something that's on there, we swab it, we send it to the lab for testing, and they have analysis. There is situations and times where there isn't enough DNA to get what's known as a full profile. So a profile meaning that they're able to make an identification of it. It's the same way if somebody leaves a print, but there isn't enough information to show that print. It's the same concept. There just isn't enough DNA, you're not going to get a full profile and they won't be able to get a match on it.
Now, going back to the swabbing of the victim's neck, you weren't present, were you, when the doctors were working to save his life?
No.
You weren't present when the nurses were assisting the doctors to save his life, were you?
No.
Okay. Do you know if they used any sort of saline on the victim's injuries as they were trying to save his life?
If he knows the answer.
No.
So you don't know everything that took place on the victim's neck while they were trying to save his life, is what I'm getting at, correct?
Correct, I don't.
And where was his injuries again?
On his neck and shoulder area.
Now, detective, when you go to a scene and you're aware that a particular person lives there, and you're in their bedroom, is it common for you to then swab their own clothing? Is that something you would typically do in an investigation?
No.
Why not?
Because if we collected a piece of clothing or an item from a person's residence, his chances of his DNA being on it are very high because it was collected from his house. We would expect his DNA to be on it.
You were also asked about processing the ammunition boxes and how you process them, correct?
Correct.
And you processed the boxes, I guess I should say, with a chemical, correct?
Correct, the chemical ninhydrin.
Say that again for us.
Ninhydrin.
I think you're going to need to spell that for our court reporter, if you could.
I'll have to look that up.
Okay.
I have to give you a correct spell.
I know it's in your report, but we can get it later. So ninhydrin, am I saying that correctly?
Yes.
All right. So you pour that all over these boxes?
Yeah, we would spray it on there, and then you can either warm it to speed up the process, or you can let it dry overnight, and that'll eventually turn purple to the presence of fingerprints.
Why decide to go for fingerprints instead of DNA on those boxes?
Because it's more conducive to process the paper for fingerprints. It's more likelihood that we'll get fingerprints than DNA.
Okay, and detective, tell us again where you found these boxes?
Inside of the blue and red Jordan bag, which was inside of the trunk of the white Cadillac.
Okay. Now, in order to get to that bag within the white Cadillac, someone had to move them there, correct?
Yep.
Okay. So someone did, in fact, touch them. Am I correct in saying that?
Yes.
But we still didn't find fingerprints.
No.
And again, just because someone touches something doesn't mean we're actually going to get a DNA profile as well,
Objection,
correct?
asked and answered.
Overruled.
You can answer.
Yes.
Can we still see the chemicals on these boxes?
You should, if it looks slightly purple, you see the slight purple on there? See, it's kind of spotted now?
Yes.
Yeah, that's the chemical that's sprayed on there. Obviously, this has been some time. It continues the process, so that's just the way that it looks now. But, and the initial reaction that we had when it's a fingerprint, you're going to see the actual fingerprint and it'll be purple.
Those cartridges, we showed some pictures earlier, and Mr. Kinmock went over them as well. The cartridges, the full, what we civilians would say is a bullet before it's been fired, right?
Correct.
That were still in the boxes.
Yes.
Why not test those
For
DNA?
Because they were inside of the boxes.
Okay. Why not test them for prints?
We tried to get prints off of them, but we're not able to get prints off of them.
All right. So even within the box, you tried as well?
Yes.
Okay. Now, with the DNA of the masks, you've already swabbed these, correct?
Yes.
You've already sent them to the lab, right?
Yes, the swabs have been sent to the lab.
Okay. Now, as someone who's been in crime scene and has been a detective for a long time now, since 2006, I think is what you said earlier, can DNA, I think you said DNA can last for years, right?
Yes.
Can be tested for years?
Yes.
But can DNA also basically die within a few hours based on its conditions that it's in?
It can be sloughed off, it can be transferred, and yes.
What does sloughed off mean?
It means that it could just be pushed away, or it could be falling off. If it's skin cells, which is not a lot of DNA to begin with, it can fall off. It could be moved, jostled around, absorbed by the paper, things of that nature.
Now, if we have DNA in a vehicle that's cooking in the hot Florida sun, could it also cook the DNA away?
Yeah, heat is not good for DNA.
Okay. Can you tell me, Detective, the white Cadillac that you found these masks in, was it operable?
No.
May I have a moment, Your Honor?
No.
Your Honor, maybe go sidebar for one moment.
He was a good lawyer. Oh, excuse me, he was a good witness. Court about to be over soon, so they doing a good job. You know what I mean? Might be ready to be over in a little bit. No. No. I don't know, did they call the jury out? I guess. Court about to be over for the day. Please, everybody, like the video, comment, subscribe to the channel, please, so y'all can know when I go live. Just hit that little bell. I appreciate everybody who watching this video. I'm a new YouTuber trying to build my community up. that's on trial, they gotta sit there for a long time. Like, they not like the lawyers. They actually gotta sit there in their seat for hours and hours at a time.
Today, Detective Wolcott has testified that not only in his collection does he swab it once, but he swabs it twice. And the collection of evidence twice is the additional swab is for additional testing. It could be by the state, could be by the defense. We intentionally stayed away that based on the court's ruling. But we are asking for the permission to ask Detective Wolcott who has the additional ability to test the items, because he has said numerous times that he asks or that he swabs it twice intentionally. The 4th DCA has ruled on a similar issue. Pacetti, spelled P-A-C-E-T-T-I, versus State, cited at 210 Southern 3rd, 681. And in that case, the court allowed the state to ask a question because there's a narrow exception regarding burden shifting. In the case at hand that I've cited, if there is a defense where there's alibi, self-defense, or something like that, where it would, the defense, and I'm using the language of the court, saying that the defense assumes some burden, then it is permissible for the state to be able to elicit testimony or present evidence regarding accessibility for evidence. In this case, Mr. Kimmock in particular has spent 2 days cross-examining CSI witnesses about where certain items are, because we believe at a time later the argument will be made that the state failed to have items tested. He's already said as much in his opening, because it is clear from the line of questioning that's come out that there's going to be arguments made and defenses made that BSO failed to do a thorough investigation. Additionally, Mr. Kimmock in particular said that his client was not present during the time of the homicide and that he in fact was at his grandmother's house sleeping. That is an alibi. That is an affirmative defense. He's saying he was not present at the time of the homicide. He was someplace else. And the only way that that alibi can be proven is, I would imagine, one of two ways. Either if a witness is put on, which Mr. Kimmock said he's going to have 3 days of a defense on a case, witnesses is put on saying that Mr. Boatwright was somewhere else other than the homicide location, or if Mr. Boatwright waives his right to Fifth Amendment privilege and testifies himself. The problem with the way that we see we're in the position, we won't know what that defense is going to be until we know. And the witnesses that are available now to just simply say, if that evidence was accessible, that's all we're asking to ask, is on the stand. Your Honor has currently made rulings in this case to say if a witness is available and on the stand and can be asked information or give testimony, then in judicial economy, you will let the opposing party ask that question. We're still in our case in chief, and now we're on a second witness. One of the witnesses, by the way, won't be available because he's leaving the country. This witness is now available in here, and we're simply asking to ask that question without argument. Burden shifting by the Florida Supreme Court and the 4th DCA has said the burden shifting comes at argument. We're not arguing that they had to do it. We simply want to know from the witness, which we believe this is the correct witness to ask, what are the available extra cotton swabs for? Who are they for? They could be for the state or for the defense. That is a material fact that they've put at issue. And we want to be able to refute that while we have the opportunity from the witnesses that are on the stand testifying about it, because they've placed it at issue. And so I would argue, Judge, that based on the precedent with the 4th DCA, and this is a very recent case, it's still good case law, that narrow exception is met simply because they have put at issue. He's going to say, and he said in his opening, Mr. Boatwright wasn't there. That is an alibi, even though I know that I argued he didn't give notice, but that's an alibi. I was someplace else when this crime occurred. I was not at the location. So I would argue that it meets that burden and that we are allowed, and it would be permissible, very limited, but permissible for us to at least elicit that testimony while we have the opportunity to.
May I approach with the case, Judge? Providing the court with Hayes versus State, 660 Southern 2nd, 257. It is a Supreme Court of Florida case. I would direct the court to the third to last page in the document. It's page 265 of the reporter. The bottom of the third to last page is the discussion that is directly on point to the issue before this court. The the Supreme Court ruled as follows. The fourth error occurred when the trial court allowed the prosecutor to elicit testimony over defense objection concerning the failure of the defense to request testing of various pieces of scientific evidence. The state called as a witness an employee of the Broward County Sheriff's Office crime lab who testified concerning various pieces of physical evidence found at the scene of the murder, including clothing stained with blood. On cross-examination, the defense brought out the fact that the state never requested a test of the bloodstains. The apparent goal of this line of questioning was to cast doubt on the thoroughness of the state's investigation and to imply that a test of the blood could have eliminated Hayes as a suspect. Then, on redirect, the trial judge overruled the defense objection and allowed the state to inquire whether the defense had requested any testing of the bloodstains. The witness replied that the defense had not asked the crime lab to test the bloodstains and added that the lab had complied with such requests in the past for other defense attorneys. Similar comments were made by the prosecutor in closing arguments concerning the failure of the defense to test hairs found at the scene of the murder. We find that the prosecutor's comments were prejudicial. In Jackson v. State, we found that the state had erred when the prosecutor commented on the defendant's failure to call a particular witness to testify. We explained, it is well settled that due process requires the state to prove every element of a crime beyond a reasonable doubt, and that a defendant has no obligation to present witnesses. Accordingly, the state cannot comment on a defendant's failure to produce evidence to refute an element of the crime because doing so could erroneously lead the jury to believe that the defendant carried the burden of introducing evidence. The prosecutor's questions and statements in the instant case may have led the jury to believe that Hayes had an obligation to test the evidence found at the scene of the murder and to prove that the hair and blood samples did not match his own. Clearly, Hayes had no such obligation. It is the exact same thing that we have here. Mr. Boatwright, we have no burden to present anything. Allowing this testimony or any comment by the state would shift the burden to Mr. Boatwright, and we object.
Your Honor, it's not. Oh, I'm sorry.
Judge, on behalf of Mr. Newsom, I would move to adopt the learned argument of co-counsel and suggest that we are in a uniquely different position. Our defense has nothing to do with the state's failure to test evidence. Our defense is simply lack of evidence, and to allow this type of burden shifting would be extremely detrimental to my client and his defense through nothing we have done to suggest in any way anything about what the state says about an alibi or anything else. The state is asking this court to depart in a major fashion from established precedent. We're asking the court to simply follow the well-established principle as announced in this Supreme Court decision as far back as '95 and still clearly the law today, to not allow there to be a burden shift. The state can test anything they want whenever they want. They failed to test items at their peril, and that's the way the law should remain.
It's not the same. What's very distinguishable from the Hayes case and what we have in the case at hand is this does not even address the exception regarding affirmative defenses, and that's what's addressed in the case that I've cited, the Pansetti. He has said, specifically Mr. Kimmock has said, that their defenses, Mr. Boatwright was not there, that he even gave the location, which is an alibi. His client, he's saying, was at his grandmother's house, which is a different location than the homicide, sleeping. He gave a location and he gave an activity that he's basically saying the state has it completely wrong. He wasn't there. That is an alibi. That is the very definition of an alibi. And the only way that that can be proven is if he puts on somebody to say, I saw him there sleeping, or he says it himself. Now, obviously, I don't have that benefit of knowing which he's going to do or if he's going to do any of it. But so far at this juncture, what we do know is the state knows that it's in a position where, A, there's evidence that we are arguing was equally available to both sides. And I keep saying that because I'll use a very seminal case from this particular county. When Deputy Brian Tefford was murdered, I believe by 2 co-defendants, and it was tried in this courthouse by, I believe it was Judge Backman. One of the things that was at issue was DNA. The defense actually requested and was permitted to test the DNA, and I believe it was on a t-shirt if I'm not mistaken, and that was what was at issue. DNA was obtained and developed by the defense. And so I'm bringing that up to say, in another homicide trial, and in many homicide trials, there's always an availability for the defense to test items. That's why we, as the state, do not, and practice, get rid of DNA items when they're done being tested, because whether there's additional testing that's requested, that it can be done. And if it's going to be consumed completely, then we have an obligation, before it's tested and consumed, to let the defense know that in case they want to test it. These are all safeguards. So for now, the impression that's left to the jury that, well, it's solely, and it is the state's burden to test whatever it tests. I'm not saying Mr. Kimmock can't make that argument. Certainly he can. But at this juncture, no party has made that argument. We're just trying to get testimony and get through the state's case. And what the state is asking for, because at the point when arguments are made, it's too late. We don't have the opportunity to rebut and refute it when all the cases are closed and we're at the point of argument. And I would argue that because it's an alibi defense, Hayes is not applicable. What's applicable is the Pansetti case, which does talk about if there is an affirmative defense, alibi being one of them, then it's permissible. And the safeguards are still there, because we're not asking to argue that they failed to do something. We are only asking, one, if anything, question or two, who are the extra swabs for? That's a fact, that he swabs extra swabs on purpose for that exact purpose. And it's used in cases all the time. So.
Okay. Anything further?
No, Your Honor. Thank you for allowing me to request it and make the record.
I understand well, let's break it down here a little bit. First of all, the extra swabs are taken in case the defense wants to ask, in case the state wants to retest, in case something, there's a number of reasons. It's not exclusively for one or the other. Secondly, the Passetti case talks about it not being burden shifting where the defense assumes some burden by doing an affirmative defense, and then the area of questioning is related to that affirmative defense. I don't know that the defense, well, certainly Mr. Newsom and Mr. Williams haven't undertaken that, and I don't know that Mr. Boatwright has undertaken an alibi defense. Once again, what counsel says is not evidence, and counsel who promise things and then don't deliver do so at their own peril. So unless he presents a alibi witness or his client testifies to that, but then, so first of all, the fact that the court allows things out of turn are for things which are logically going to come in one way or another. The things like an alibi, that's to get into what Passetti envisions is definitely a condition proceeding. It has to happen beforehand. You can't say, well, in case they put on it, they may not put on a case at all. Defense, boat right rests. Okay? Then I've let this in? No. And secondly, I think Passetti talks about if they raise an alibi defense, something that goes to that alibi. In that case, what happened was they raised an alibi that he's with the girlfriend. The girlfriend is more available to the defense than it is to the state, although all witnesses are available, and she simply refused to cooperate. And what it said there was it was fair comment to say defendant's claiming he was with the girlfriend, told him to take a hike, and it's not a very good alibi. And that's what that case stood for. The Hayes case is very similar to what we have here. The slight difference in Hayes and what we have here is where the Supreme Court said in Hayes the prosecution crossed the line in that they said you should have tested. And that's somewhat different than what you're asking to do, saying, can anyone? All right? So there is that distinction. But on the whole, Hayes is a closer factual scenario to what we have here. And I don't believe that what counsel may have said in their opening amounts to them having put on an affirmative defense. And even if they put on an affirmative defense of alibi, I don't know how that goes, then ties into cross-examination about you didn't test this, meaning, well, you could have because you're raising an alibi defense. I don't see that. So I appreciate everyone's arguments. My ruling will remain the same. I'm not allowing the question.
Okay.
Thank you. So let's bring them back out. And did you still have any read?
I don't believe so. If I can just confirm with co-counsel.
Just confirm, but let's get the witness back on the stand. We'll get them out in a second, and then I think it'll be time for the weekend.
No further questions, Judge.
All right. Well, I'll let you.
We'll say that in front of you.
Yeah.
I just wanted you to know, so you know where we're going.
Either way. All right, bring them out.
Jurors are entering.
Parties may be seated. The court will come to order. The parties are present. The jurors are present. Any redirect?
No more further questions, Your Honor, at this time. Thank you.
Thank you. You are excused. Please do not discuss your testimony with any other witness. Well, it's after 5. I think that brings us to the end of another day. So, as with each time we break, I will remind you you're not forming any definite or fixed opinions on the merits of this case to hear all the evidence, arguments, counsel, instructions on the law by me. Until that time, you must not discuss the case even among yourselves during the course of the trial, take regular recesses during which you're permitted to separate, go about your personal affairs. During these recesses, you will not discuss case with anyone or permit anyone to say anything to you in your presence. Anyone who attempts to, tell me on the jury, ask them to stop. If they persist, leave them, report the matter to one of my deputies. If you see counsel, witnesses, defendants, anyone else associated with this case in the hallway, they're going to ignore you because they're rude. No. They're not rude. They're following my orders. All right. And please, over the weekend, make sure you insulate yourself from any inadvertent media or outside sources. So Monday is a holiday, and we will not be in session on Monday. Please enjoy the long weekend, or if you have work and you want to go in for a day, you can do that if they're open. That's entirely up to you. You're at your own liberty on Monday. We will reconvene at 10:30 on Tuesday morning and press on from there. Once again, thank you for your time, your attention, your service. Have a wonderful weekend. We will see you Tuesday morning.
Thank you, Judge.